Shikha Sahayaka Dhananjay Tanjay case cover, both they are not allowing their arrear salaries from the period of 26 July 2014 to
5320.
5320.
Where is your representation?
I have representation, but identical matter both have the 1 and 16 are same manner. 1 and 16. In case of 16,
Annexure 9, you take call on that.
Yes.
Annexure 16, my lord.
Petitioner's representation dated
No date, no signature. Page 14.
dated seeks payment of salaries and differential emoluments for the period between 26/7/2014 and 5/3/2020. First, the undated document is at Annexure 9. First, counsel for the petitioner submits that if a direction is given to consider the same, justice should be done to client. If such consideration takes place in the light of Dhananjay Charan Dev versus State of Orissa, WPC number 31679 of 2011, which attained finality at the hands of the Apex Court in SLPC number 13627 of 2021. First time. Next paragraph. Learned AGA Mr. Lenka points out that the representation lacks the credentials such as date, signatures. And therefore, if a fresh representation is given, there would be no difficulty for considering the same. First, with this proposal, counsel for the petitioner is agreeable. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to make a fresh representation within 2 weeks. And if one is made, a decision thereon shall be taken within 8 weeks following the same. First, all contentions are kept off. Next.
Well, item number 16 is a similar matter, but that representation was refused. Rejected.
Then
notice.
For the notice matter.
What is all?
Unless 10 is the notice matter. Okay.
All.
Item 2.
Yes.
In this case, the petitioner is a registered welfare organization, my lord. He has been conducting some cultural program during the Khandagiri Mela
Application to be
festival.
disposed of.
Yes, my lord. Annexure 7 is my application.
Yeah.
My only humble submission till disposal not to allow second organization inside the boundary wall of plot number 143 part.
We will direct them to consider your application.
Yes, yes. But till disposal, my lord.
Application dated
8/4/25.
8/4/2025. The copy whereof avails at Annexure
Annexure 7.
7 seeks permission
OP number 1 and 4.
at the hands of OP numbers 1 and 4. For what purpose?
Purpose,
stage
my lord,
opera.
there is a land, my lord,
For
the vast area of the land, 143.
for staging opera show during the future period of Khandagiri
Mela
Festival.
2026 onwards. First half. Learned counsel for the petitioner submits that the claim partakes essential religious practice and therefore a decision has to be taken by the jurisdictional authorities of the same on a war footing. First half. Next paragraph. Learned AGA Mr. Renka appearing for the OPs agrees to instruct OP number
1 and 4.
1 and 4.
1 and 4 to look into the grievance of the petitioner in a time-bound way if all contentions are kept open. First, with this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances,
Till disposal, not to allow any other organization inside the boundary wall.
the other
Of one
claim is rejected. Next.
Item 3. May I please? Madam, this matter has been listed for the limited purpose. My miscase has been filed under flag C matter. But here the case is that the application of a legal hair certificate which has been rejected by the Tahsildar and subsequently the appeal made by the before the sub-collector was also rejected, review also rejected, and collector, the filed an application before the collector exercising a second appellate authority which is not permissible under the miscellaneous
No
rules.
second appeal.
No, collector. If the original authority is the collector, sub-collector is the appellate authority. If the original order passed by the sub-collector, collector is the appellate authority. And the appellate order of the appellate authority is final. But the collector exercising excess jurisdiction and passed the order, satisfying the order of the Tahsildar as well as the sub-collector.
I am for the opinion number 1 and 2.
1 and
If I read it
What's your answer to that? Sri Krishna Cinema versus so and so. What he says supports the view.
That's it, sir.
against the sub-collector order, revision is live because the sub-collector man.
No, but why? How appeal could have been?
No man.
Revision lies against that order.
No, man. I'm reading this provision, man. My lord, first of, here I am reading provision 3D, 6 and 8. 3 provisions I am reading. Now the 3D speaks of the miscellaneous rules. The legal and
The petition, Mr. Lenka.
No, your last occasion, your lordship directed to serve a copy. Not served.
No, I have also served.
I don't have any file also.
I have served copy, man.
Give copy. One more copy.
One more copy I will give, but I have served before the.
No, I don't dispute that.
Yes, I will serve.
You serve copy. I'll call this matter next week.
Let
him look in.
Only by my prayer. Only
Without serving copy, what is your prayer? You should know what is the case.
Yes.
my respectful submission.
Next.
They have only the flag C, not the call. In the meantime, my lordship, only submission. When your lordship has considered, my lord, I have only one submission.
No submission. Yes, next.
Next week, my lord.
Yes, next week. Serve copy. Petitioner to serve copy on the learned first up. If service is made, post it next week. Otherwise not. Next. Item 4.
Item 4, my lords, differential salary representation pending, and your lordship has been pleased to dispose of. I have served a copy of my lord senior also. Same matter, my lords, same representation, same issue. I have corrected, my lords.
Correction.
Grateful, lords.
Next.
Item 5.
I'll call your matter on Monday. Monday.
Saraswati
Call that
Bhoi.
matter on Monday. In the meanwhile, you give copy. Okay.
RSP matter regarding your lordship, Saraswati Bhoi course.
Give copy.
All sir.
All same.
Yes, sir.
Item 6.
May it please your lordship.
Yes.
I am appearing for the petitioner.
Okay.
Your lordship kindly turn to page 9. A complaint has been lodged against an advocate. The prayer is in the complaint petition. Your lordship will kindly see page 9, last 4 lines. Intervene in the matter to get relief from advocate Sangramjit Panda. Suitable action may please be initiated to get no objection consent before 12 January 24. Lordship may kindly turn to the next page, page 10. On 12 January, consent has been given and he has written this to the Secretary Odisha State Bar Council.
They returned also.
My lord. And now proceeding has been drawn against him.
Issue emergent notice. Stay of all further proceeding next date of hearing. Okay.
Item 7.
May I please, Your Lordship? There is a gross violation in the reservation for women while publishing the file and select list for the post of junior teacher. Number of matters in this light are pending before Your Lordship. Let this
Issue
matter
emergent notice,
stand.
Mr. Lenka, you request to show sub notice for OP numbers. HOP. 1, 2,
Note.
1 and 2. Emergent notice to the rest. Call along with WP number. Okay. Give that connected matter.
Yes, I have
Yeah.
already given.
Next.
Item 8.
Clerk, I filed a present in action of opposition for sanction of a block grant pension man. Similar matter already issued notice.
Notice is ordered. Next issue emergent notice. The AG is requested to accept notice for OPs. Call along with. Next.
Item 9.
36 also same.
36 same.
Yes, ma'am.
36.
My lord, your lordship's order, my lord, similar order may be passed.
Which one? 9.
9.
What is that matter?
My lord, guest teacher matter, my lord, government SSD high school, my lord.
Yeah, Annex of 6 is pending.
Issue emergent notice, Lanka such notice for OP numbers. 1, 2, 3, 4. All OPs.
My lord,
Call along with WP number 32003 of 2025.
my lord, item number 33, my lord.
Same.
Same matter, my lord.
33 also. Yes.
Item 10.
Item 10.
Yeah.
In the block grant school seeking pension. My lord, yesterday item number 22, your lordship was pleased to dispose of with a rider that within 4 months they will consider in the light of that judgment and they will grant
No.
2 months. From 2 months.
The outcome of the Hemanta Chotrai case.
Subject to yes.
Yes, that.
And provisional pension if necessary, my lord, maybe.
No.
The subject matter of this petition is substantially similar to the one in WP.
Yesterday, item number 22, not yet uploaded.
22. The same order. Similar to the one in WP number, so and so, between so and so. Wherein the operative portion of the order reads as under. First half. Next paragraph. The Learned Counsel for the petitioner submits that the similar cases should be decided similarly on the principle of clarity, and therefore whatever relief has been granted to the coordinate in the coordinate case needs to be extended to his client as well. First half. There is what in this submission. Next paragraph. In the above circumstances, petition is disposed of, granting the same relief as has been granted in the cognate case. Mutatis. Serial number 22 of yesterday.
Pardon to my lord.
11
My lord.
also same.
Pardon to my lord.
11 also same.
And also same.
My lord, my lord.
Same.
Pardon to my lord.
23 also.
Pardon to my lord. My lord, item.
11, 23, 10. Okay. Yes,
Item 8 also same, my lord.
Huh?
8, item number 8, my lord.
That is also already issued.
Notice what is similar issue.
Similar.
should be made.
Yes.
8 also.
8, 36.
8 and 36.
Yes.
Okay. Be fair to the court. Do not mislead the court. Because once you mislead, I pass very bad orders. Okay?
Item 12.
My lord, item 12, the petitioner's vehicle is engaged in the office of the opposite partner 2 on monthly hire basis. And on 9/10/23, as per agreement on the Annex 2, my lord. And the quotation is invited by the opposite partner 3 on 3/10/2025 for the vehicle for hire, and the petitioner have participated in the quotation, but his vehicle is disengaged under Annex 5, Annex 4 on 19/11/2025. But that is a finance department instruction as page 23.
Term of contract was for 2 years, that has been expired on 28 September 2025.
My lord, kindly see the page 23, my special.
28/9.
Yes, that expired. 2 years. Then press tender call notice has been invited and his term has been expired. His vehicle is no more under engagement. Your lordship may kindly see Annex 4, page 19.
That is a decision letter, my lord.
Annex 4, page 19.
Yeah, they said.
My lord, kindly have a glance to page 23, my lord. That is finance department instruction, the clause 15, the period of contract shall be for a 3 years and which may be extended by maximum 1 year subject to satisfactory performance. Now kindly see the page 23, clause 15, my lord. XIV, clause 14.
It is 3 years.
But it is 3 years.
3 years, he shows that
Finance department instruction, my lord. There is instruction is there.
No.
Under Annex 5, my lord, page 23, my lord, kindly see her appearance.
But the contract was for 2 years.
Yes.
That is the contract 2 years, but we participate in the quotation, but there is a time to open that quotation at 3 p.m.
Take notice, let us examine.
As
Second, period itself is over on 28/9.
And fresh tender call has been protested.
Item 13.
I state another state on data distance state of at least.
Yes, because your period is over, brother.
That is true, madam. That I don't dispute. But the finance department data is showing that it must be 3 years. But it stay must be granted, madam.
There must be granted.
Not must be. I pray for stay.
Fresh tender call notice has been invited.
He participated in this.
You have participated in the first time. Then what? How can we issue interim order to you? If you have participated in the fresh
But you have to
tender.
consider suddenly the distance by vehicle without intimating without mention any reason for that. I don't know the state at least
January. Call in the first week of January. Okay.
at least stay.
No. Yes, next.
Item 13.
That's a cover.
Yes. Arrest. Yes. Ashok Mahapan.
Yes.
Item 14.
14, my lord, the petitioner is working as a government teacher in government higher primary school, Board of Pokhariya, Nilagiri, Patna, Tangi block, Kamegana, Khurda district, my lord. He initially prayed for a transfer from the Tangi block to.
Transfer application should be considered.
My lord. That was
considered.
provisionally.
Annex 3 is there.
They have rejected it.
No, my lord. Provisionally, it was approved by opinion number 4, block education officer.
But they have to take a decision on that.
My lord.
Let them take a decision on that.
My lord.
The short grievance of the petitioner is as to non-consideration of his application for transfer.
Dated 18/11/25.
The said application is dated
11/25.
and a copy thereof.
Annex 3.
First one, learned counsel for the petitioner submits that even when there is a recommendation from the higher authority, still the subject application has remained unconsidered and therefore interference of this court is warranted. Next point. Learned AG, Mr. Lanka, in his usual fairness, submits that he would instruct OP number 2
Yes.
to look into the grievance of the petitioner as has been aired in the subject representation within a period of 6 weeks, if all contentions are kept open. With this proposal, counsel for the petitioner is agreeable. Next one, ordered accordingly and it fiction is put off.
That was approved, once line, the transfer application was initially approved by opinion number 4, block education officer, Tangi,
Counsel submits that the transfer application
Not approved or approved?
by OP number 4. OP number 4. Yes.
Item 15.
May I please your lordship on behalf of Mr. Devendrath Mishra, my lord?
Yes.
Here the petitioner is a widow and praying for revised UGC scale of pay of her husband and her
Now husband is alive or dead?
dead man. And she is also getting a pension, only revised UGC scale of pension.
If that
And
scale is given, higher pension she will get.
my lord.
Where is your
In this regard,
Annex 9, my lord, page 47.
Petitioner is grieving against non-consideration of her representation dated 17/7/2023, a copy whereof awaits at the exact 9, wherein she has sought for revision of her deceased husband's pay scale.
my lord.
So that once that hike happens, incidental hike she will get in terms of pension. First one. The net counsel for the petitioner submits that the authority is not taking any decision on the subject representation and therefore they should be directed to take money. Next part. Mr. Lanka, on request appearing for the OPs, agrees to instruct OP number
2, my lord.
My lord.
to look into the grievance of the petitioner as has been read with the subject representation within a period of 6 weeks. 6 weeks.
Yes.
if all conditions are kept open. First one, he also puts the caveat that the petitioner should cooperate by furnishing necessary information or records when called upon. First one, with this proposal, counsel for the petitioner is agreeing. Next one, ordered according to the petition is disposed. Next.
Did look. Item 16 has been adjourned. Item 17.
16 not adjourned. Is to notice.
Notice is. Next.
Here, revised scale of pay.
That is the revised scale of pay, my lord, and the seventh pay, and allowing the petitioner to draw the seventh pay benefits. That is the
Where is your representation?
Annexure
Mr. 4, my lord.
Petition prayer reads as that. Next slide. This counsel for the petitioner draws attention of the court to the representation dated 14/10/2025, a copy whereof lies at Annexure 4, wherein certain financial benefits on account of seventh pay with effect from 22/8/2025 has been sought for. First one. The net counsel for the petitioner requests that no decision is being taken on the subject representation and therefore interference of great court is eminently warranted. Next one. Mr. Lenka, which respondent?
Three, my lord.
Said.
I pardon.
Mr. Kotinam, it will be the grievance of the petitioner within 8 weeks if all say. Opposite terms ordered according to the petition is disposed. Next.
I pardon. My lord.
Yeah.
The annexure 4 be disposed of, my lord, taking into account annexure 2 series and 3, my lord. That 2 series.
To be stated that the consideration of the subject representation should take place in the light of documents at Annexure 2 series.
And 3, my lord.
2 and 3.
My lord.
2 and 3 series.
Item 18.
May I please, your lordship?
Yes.
Lordship, the petitioner is a 80% disabled person who is a commission agent.
Renewal Commission.
Yes, your lordship. There was an inquiry conducted against me in which it was found that 12 lakhs was misappropriated by me. Immediately, when the inquiry ended, I deposited 8 lakh rupees and willing to deposit the 4 lakh rupees. But what happened?
Take notice. Emergency. Next.
Item 19.
Matter relating to MSCP, my lord, despite the petitioner completed 30 years of service, the opposite party are releasing the MSCP in his favor. In this regard, he has filed one representation under Annexure 2 pending before the opposite party number 4, my lord.
Petition prayer reads as 182. Next one, counsel for the petitioner submits the. Before presenting the petition, we had submitted the representation dated.
Madam?
Representation dated.
Dated 18/7/2025.
18/7/2025. A copy whereof avails at Annexure
2, my lord.
So for granting MACP in his favor. And that no decision is taken on the same. First one, Mr. Lanka appearing for the OPs fairly agrees to instruct OP number 2 to take a decision on the subject representation within 6 weeks if all contentions are kept open. First one. However, the caveats that the petitioner should cooperate in furnishing necessary information and documents as are required for taking the decision. First one, with this proposal, counsel for the petitioner in favor. Next one, ordered according to the petition is disposed. Next.
Item 20.
Thank you, Your Lordship. At the limited prayer, that opposite party number 4 that recorded the village pond and adjacent land in his name without the prior knowledge of the villagers. For that reason, my lord, this present petitioner along with other filed their representation and before the collector and Tahsildar, but it is still pending. It has not been disposed of. For that reason, my lord, my humble submission before your lordship that collector may kindly be directed to dispose of my representation by Annexure 2 page 14.
OP number, who is that OP number?
OP number 4 is the private person.
He has taken the
Yes, my lord, village pond in his name. And that village pond was, my lord.
Short grievance of the petitioner is that the OP number 4 has got the entries in respect of the public property mutated in his favor. And that despite giving a representation, the OP numbers 2 and 3 are not taking any decision on the same to restore the property to the public at large. First, learned AGA Mr. G.
My lord, there is a priority to quash it. Certiorari
The certiorari we cannot, but you consider the representation.
Consider the record.
After hearing other side also. G submits that he would instruct OP numbers 2 and need to look into the grievance of the petitioner as has been heard in the subject representation. After giving an opportunity of hearing to the private party number for OP number 4. This is absolutely first, but in the above circumstances, petition is disposed of, describing a period of 8 weeks for taking the decision. First, all contentions are kept open. Registry present a copy of this order to OP number 4 by speed post. Since notice to him is dispensed. Okay.
Item 21.
My lord, I prayed for to except a date in which, my lord, that representation will be
8 weeks.
But this case is covered by the judgment of Dixit Ray's
Right.
case. Yes. Where financial benefit has been granted from 1/10/2017 instead of 1/1/2016.
Any representation is given. Similar matter we decided
Yesterday,
yesterday.
item 45 of the
Item 25.
item 45 of the yesterday's list.
Item 45. The subject matter of this petition is substantially similar to the one in WP number so and so between so and so whereby
That is WPC number 34926 of 2025.
25 between so and so, wherein this court while order dated yesterday has observed as an operative portion. First, learned counsel for the petitioner submit that like cases should be decided alike and the relief granted to the litigant in the coordinate case has to be extended to his client as well in the light of Dixit Roy versus
Reported in 2004 2LR page 718.
Dixit Roy versus State of Orissa, 2004 2 OLR 718.
Which has been confirmed by the Honorable Apex Court.
It is said at the bar that the said judgment has been affirmed by the Apex Court as well. First, next one, in the above circumstances, the relief granted to the cognate litigant being extended to this petitioner as well. But that is within us. Next.
Item 32, there are two matters. Both are same.
Same, 32 also.
32 also. There are two matters.
Yes.
Item 22.
Let the present petitioner working as TGT Science. Present petitioner working as a TGT Science teacher, SSD High School, Ambadala, Muniguda Block, Distrayagada, challenging the arbitrary action of OP number 1 and 2 for not providing financial.
Tribunal's order is not implemented.
Yes, my lord.
Where is the tribunal's order?
My lord.
No, you should execute, can't you file execution before the tribunal? Execution lies, na?
Contempt lies there.
Contempt.
Here, contempt lies with the tribunal.
Tribunal itself.
Administrative tribunal.
No, this is which tribunal?
Education.
My lord.
This is administrative tribunal.
Administrative tribunal.
Lord, several are
As well as been abolished.
No, because therefore then it has to become here only.
Yes.
after that, several reads also filed in High
You
Court.
should notice, Mr. G. Yes. G requested to accept notice for OTs, emergent notice to file. Okay.
Item 23 has been disposed of. Item 24.
This.
Item 24.
Item 24 is a case
For promotion.
promotion, Chittaranjan Das case.
Counsel is not present.
Notice the manner.
Notice, issue notice. But consideration of representation is there.
Not me direct that.
Petition clearly reads petition is presented after giving a representation dated 22/7/2025 40 whereof avails at an exact form wherein the request is made to place the petitioner the grade of lecturer with the A scale of with effect from 17/10/2006 and reader scale of with effect from 17/10 with effect from 17/10 with effect from the same date. First, let the AGA Mr. G agrees to instruct OP number. OP number 1. OP number 1 to look into the grievance of the petitioner as has been held in the subject representation with a reasonable time is granted and all contentions are left open. First, he also puts a caveat that the petitioner should cooperate by producing person the parts for documents as are required for due consideration of the subject representation. Next paragraph. This is next in the above circumstances, 8 weeks open to solicit.
Item 25.
May I begin? The petitioner challenge the inaction of opposite party number 2 and 3, my lord, not to construct the Anganwadi center. Although the government has sanctioned 8 lakhs for construction of Anganwadi center, my lord. Unnecessary 2 is the depreciation, that is the pending, my lord. Unnecessary 1 is the work list.
Construction of Anganwadi center.
Center, my lord. Government already sanctioned, my lord, 8 lakhs, my lord. Unnecessary 1, yes, unnecessary 1, my lord. Page 8.
When it was sanctioned?
Work will start on 1st April 25, my lord. But till date, they have not started the construction work, my lord.
Who should start construction?
The opposite partner, 3, my lord.
3.
Yes, ma'am.
Mr. G, just instruct the short grievance of the petitioner is that though the amount has been sanctioned and plan has been approved, the Anganwadi center has not yet been constructed, and as a consequence thereof, the children are put to a great prejudice. First of all, counsel draws attention of the court to the representation they did.
Dated, my lord?
21/7/2025, a copy whereof lies at an extra 2 series in that connection. First of all, learned AGA Mr. G appearing for the OPs agrees to instruct the OP number 2 and 3 to look into the grievance of the petitioner as has been held the subject representation in a time-bound way. First of all, it hardly needs to be stated that an Anganwadi center is a center of education where instructions are issued to the children of tender age. First of all, when the amount is sanctioned and plan is approved, there is no reason for keeping things in the limbo without undertaking the construction. First, next one, in the above circumstances, petition is disposed of, directing the OP numbers 2 and 3 to look into the grievance of the petitioner within a period of 4 weeks.
I will pardon, my lord. Item 24. 24.
24.
Yes, this I am permitted to file a fresh representation, only this one.
Why we have given made that order? There is a representation given already.
But I am permitted to file a fresh.
You want to withdraw the petition?
No.
I want sentence with that 24. Being open to the petitioner to file a fresh representation as well, giving full particulars along with watching material. Next.
Item 26.
May I please, my lord. I am challenging the order of rejection, my lord. You will also issue the similar cases. Notice, my lord.
This all along with WP numbers of we requested to accept notice for OP numbers. Next.
Item 27.
27, my lord, the second round litigation. Now the claim has been rejected and similar batch of cases will also already issue notice.
Issue notice. He requested for notice. All along with WP numbers. So
all the matter same.
Item 28.
May please, Lordship. Only the petitioner was placed under suspension. Thereafter, he was reinstated. He was a headmaster in the school. But reinstated, not in that school, but in another school reinstated without any transferring matter. So now 6 months service is left for only for retirement. Now he will face this trouble for regularizing everything, my lord. Only that is 40 kilometers away from, that is from the original school now at the age of 60, my lord. Only I have also taken the leave from your lordships only for agitating second times, that is if any inconvenience, my lord. Now, because earlier he was in the writ petition and disposed of and reinstated of service, only my prayer is only to, that is why to
the same school.
Same school, man. This is because 6 months service only left.
There was a order of suspension after
Revoked.
But you have reinstated him, but you have proposed him to some other school. What is the allegation?
I do not know that allegation.
What was, why you were placed under suspension?
Allegation only there because he was holding, there is a union secretary, teachers union secretary.
That is not
Frequently, let me complete. Frequently he was going to the authority, my lord. Only there is the agitating management regarding the grievance of the many teachers. And they have also in the combined petition that alleged before the MLA and the Minister of the Education regarding the inaction of the authority. And vindictively, my lord, he was placed under suspension. Only false allegation that he was addicted with some liquor, anything like this. But there is no proof, my lord. So thereafter,
The inquiry has to take place now.
my lord, that now 6 months only left, only 6 months time, only determined.
Correct.
Because he, without any transfer, nothing, without any regularizing, he has been pushed, reinstated in another school. But in my lord, it is not that is law does not provide, then he reinstated in there. Only reinstated in the same school, thereafter he may be transferred. Now, without reinstating in the same school, how, my lord?
Mr. G, just take notice and come back with some short reply. G is requested to issue emergent notice. G is requested to observe notice for peace. Matter lies in a short compass and call this matter in the first week of January.
Date will be, my lord.
First week of January. Next.
Item 29.
29, my lord. Some period of increment arrears has not been sanctioned and released by the OP number 5. In this regard, OP number 4 issued letter and bills which has been pending before the OP number 5. Thereafter also Annexure 7 is pending representation before the OP number 5.
But petition prayer reads as under. Learned counsel for the petitioner submit that though there is a recommendation from the jurisdictional authority to accord the benefits, the same has not been accorded. And first, he also draws attention of the court to the representation dated.
So many representation there. Last representation is 3/2/25.
Series of representations given in this regard. Saying that the same have remained unconsidered and that there is no hope of being considered in the near future unless the court plans. Next one. Learned AGA Mr. G very fairly submits that he was instructed OP number 2.
OP number 5.
OP number 5.
5.
To look into the grievance of the petitioner. As has been aired in the subject representations within a period of 6 weeks, if all contentions are kept open. First, he also puts a caveat that petitioner should cooperate by producing necessary material if required. First, with this proposal, counsel for the petitioner orders. Next, ordered accordingly, did petition is disposed.
Item 30.
Item 30 may please, my lord. The petitioners are the guest teachers. Their main grievance in this writ petition is to adjust them against the available vacancy because the authorities are going to terminate them by virtue of advertisement under Annexure 4, my lord. Your lordship in similar matter has issued notice, my lord, that is WPC number 3200.
Issue emergent. Learned AG is requested to accept notice for OPs. Any interim order is granted there?
No, my lord.
No.
In that case, interim
All
order.
this matter along with the mapping number. So,
My lord, in this case, my lord, I filed on IA because, my lord, the petitioner, they will immediately terminate the petitioner by giving effect to the advertisement under Annexure 4.
no advertisement, then many people have to apply, then everything has to
There
happen.
is a
na?
procedure.
Yeah, there is a big procedure.
Man.
Okay. Let us see that after notice is served. Call in the first week of January 2020.
This case may be tagged with the WPC number 800.
Yes.
Population.
Item 31.
May I please also? In this case, the petitioner challenging the order.
What has happened to your hand?
Honorable
Accident.
Lordship, in this case, challenging the order dated 30/10/2025, in Extra 17, Your Lordship, which is by the opposite party number 2, Your Lordship, page 67, Your Lordship, in Extra 17, where, as per the BO's report, the director, Your Lordship, passed the order, Your Lordship, which is completely false, Your Lordship, stating therein that Your Lordship, kindly see.
Issue emergent notice. Learned AGM Mr. Mohanty is requested to accept notice for the notice. First.
And I have filed one name. Your Lordship, kindly visualize, Your Lordship, next 16, Your Lordship.
No.
Because they are now going to fill up the post of the BO, Your Lordship. Next promotion, Your Lordship.
Any promotion shall be subject to outcome of competition. Yes, next.
Yes, Lordship.
Item 32, 33 have been disposed of. Item 34.
Miller, adjournment Monday, Miller.
You want adjournment?
Yes, ma'am.
What is this matter about? You want appointment to the petitioner and relay application scheme.
Yes.
Where is your representation? 3.
34.
In exit 3. What?
Item 34.
This is in respect of the rehabilitation assistance scheme.
Where is the application? Where is the application? Give our petition to madam.
Action on my senior team.
No adjournment. When we can grant relief to you, we can grant relief. I mention your name that you argued very well. Okay.
Urgency.
Notice can be issued because it is a 90. Subsequently, Jita will come into force. If at all they will come within that purview.
Issue notice.
Notice
Requested to accept notice for notice. Matter relates to pension, therefore, was taking the third week of January 26.
Item 35.
The petitioner initially engaged as Hindi teacher on contractual basis, and thereafter his service has been regularized as per the 2022 rules. And while he was continuing, he was straightway disengaged from service without following any procedure, for which he approached this on court, and this on court granted interim protection, and thereafter he was allowed to continue throughout. And finally, the petition was disposed of on Excerpt 6 manner, directing to issue a formal order of absorption. Now, my lord, thereafter content was also filed, and now in order to implement the order, now Annexure 8, instead of issuing a formal order of absorption, they have issued a fresh appointment order. That is I am challenging because Annexure 8.
Take notes.
I have made a grievance with the authority, my lord. Let them
49 and accept 10 the representation.
How they will consider when there is such an order already?
Therefore, relying that earlier judgment, I made a representation. Instead of fresh appointment, it should be formal order of absorption. Let them consider
the grievance of the petitioner is as to non-consideration of his representation with 7/8/2025 copy whereof avails at the lecture 10, wherein he has sought for issuance of formal order of absorption in the light of direction issued by coordinate bench of this court in his earlier WPC 33272 of 2023.
And batch. There are 3 cases.
And etc. Comma etc. Etc. With effect from 2/6/2017.
Well, that is my initial date of joining.
First, counsel for the petitioner submits that that representation is considered keeping in view the observation of the coordinate bench, justice would be met to this plan. First, next paragraph. Learned AGM Mr. Mohanty appearing for the office very fairly agrees to instruct OP number.
OP number 3, collector, my lord. That is OP number 2.
OP number 2 to look into the grievance of the petitioner in a time bound way, within a period of 8 weeks, if all credentials are kept open and the petitioner also cooperates by producing necessary material for information as may be required for due consideration as the subject of presentation. First one, this is appreciable. Next one, ordered accordingly and in petition is disposed of.
Item 45 also same.
Same. In that WP number?
WPC batch cases, 3 cases. 45, 35 and 45. Same.
Item 36 has been disposed of. Item 37.
Lordship, I was ostracized because I was ostracized from getting basic amenities, agricultural assistance for cultivating my land by the OP number 7, 8, and 9. So that my life become a hardship in my village. I have to go miles for getting different rations or essential commodities. And when my brother came in my rescue to help me, to assist me, he was also ostracized. So cause of action arose on 30th July 2025 when petitioner was initially boycotted by OP number 789. Then on 14th September 2025 when petitioner's brother was also ostracized when he came to rescue the petitioner. Then came on 24th September 2005 when the petitioner lost the FIR by Ganjam PS case number 300/25, but no result. Then came on 3rd October.
Monty, why all this is happening in the state? Just look into that and have a conference with your official clients and come back on the next date of hearings.
Okay. Issue emergent notice. Learned AG,
Please, Lordship, please provide us police protection because all are terrorizing me and also the persons who are coming to rescue me.
Wait, there are 140 crore people in the country. If everyone needs to be given police protection, we have to hire the police from outside. That will be impossible. Just wait.
Police can declare.
Issue emergent notice to others.
1 to 6
previous.
1 to 6, I very will take the instruction. But 7 to 9, they are all private files.
Okay. Yes.
Item 38.
If my lord, this batch of cases are covered by Saraswati TV. I have given the corrected copy.
Correction. Yes.
Item 39.
Ashok Mahapatra.
No.
Both matters.
Mine. Item 46 also.
46 also.
Mine.
Item 40.
My places. In this case, petitioner is a retired teacher, not teaching and non-teaching staff of the aided high school, my lord, seeking gratuity. Your lordship also dispose of similar matter. Dispose of
15.5 months pay.
My lord, instead of 7.5 months, my lord.
What we have done in similar matters.
My lord. Your lordship also disposed of yesterday item 50, my lord. This is the coordinate bench matter, my lord. Yesterday item 50, my lord, serial number 50.
Item number 50.
My lord.
No, anyway, you have changed the factors according to this. We can do that.
My lord. Only last part.
Huh?
Only last part, my lord. Without expressing any opinion, that part may be.
Yeah, but that's right. But without expressing that, we will remove that. All right.
The copy did them.
remove it in this also.
Connected matter also same.
Huh?
Connected matter also same.
Same. Okay.
Only representation to OP number 3.
Okay.
Of Lordships.
Item 41.
The present petition has been appeared in the selection process conducted by the Odisha Staff Selection Committee Bhubaneswar for the post of leave training reserve teacher in 2024. As per this,
Similar orders already we have issued notice.
Yes, ma'am. Issue notice when the BSc same accepts notice for voting number 182. Patanaik.
Mr. Sanjeev Swain.
See, Sanjeev Swain, the panel council is requested to accept notice for OP numbers 3 and 4. Petitioner to serve copy of the petition on the panel council right now.
IA is there, man.
Yes, no.
Item 42. All along which is that connected matter. We have connected matter.
Provide the number.
Day before yesterday it was there at 2 p.m.
Correct.
Item 42.
May please, Lordship. Like it's a covered matter by your Lordship's judgment. The petitioner has been transferred at the cost of the open number 6 by the recommendation of the MP and MLS, my Lord.
Mr. Sen will allow this petition. The subject matter of this petition is extensively instituted one in WP numbers 20875 of 2025 and the batch disposed of by this court by the order dated. Where is the order dated?
In the judgment. Transfer order. Wherein the transfer of the kind of being set aside as being contrary to the normative process laid down by the state-wide guidelines dated 14/5/2025. 21. First one. Next one. In view of the above, the impugned order so far the same relates to repetition is allowed. The impugned order so far as it relates to the petitioner is set at one. First, other observations made in para 25.
4.7 million. It's because in the meantime I have already joined.
7 of the cognate judgment shall be applicable to petitioner as well. Okay.
Both the matters same.
Same.
Well,
okay.
Item 43.
Yes.
We are licensed photographers, my lord, for Konark. We have gone through the examination, Bhaivavas and all that pursuant to ancient monuments and archaeological sites.
Renewing your license, sir?
Renewing my license, I am there. Each year it is to be renewed on payment of 25,000 rupees and application. This time, because of a contempt is pending, that is the inside reason that I cannot say officially. They have not renewed it. And we are the only person who is authorized to enter into this, my lord, Konark site. So there is a chaos.
This renewal of licenses is done under which rule?
Rule is, my lord, the rule is policy for archaeological survey of India photographers to perform within centrally protected monuments. Section 5 of Rule 5 thereof says written test and practical and Bhaivavas to be selected 3 process. That is how we are selected, my lord, depositing 25,000 and all that. Issuance of license, renewal of license. Every license will be renewed annually subject to applicable policy guidelines and the terms and conditions, if any. The renewal of license, the licenses shall be renewed subject to pending complaints, if any, against the licensed photographers who intends to renew his license shall be taken into account at the time of renewal.
You take notice, Mr. Rangi, so that next week we can dispose of the matter.
I had given copies. I don't know. Government of India survey, we have given copies.
Issue emergency notice.
I have also filed an IA. Tourist season, chaotic situation.
We'll have it next week.
That is some
issue emergency notice. DST, Mr. Padi requested to accept notice for OPs. First, matter lies in a narrow compass and urgency is needed. First, therefore, call this matter next week. Okay.
Item 44.
Yes.
Item number 44 may kindly pass over. Kindly be the last item before lunch.
What is for?
Pass over last item before lunch, Your Lords.
What is this matter? Let us see.
So this is a staff selection council.
We have issued notice in that one. We have issued notice in the other matter yesterday, today. We will issue notice.
My humble sons.
Your senior has told not to argue.
Pass over last item before.
Pass over. Yes, Mr. Sarangi, why you are there?
No, notice has been served on them. Copy has been served on them.
No, copy is served on them. But now you inform him that I am calling this matter next week. If they do not come ready, then I may permit you to go do
I'll
it.
file a memo accordingly.
Well,
Serve the copy on them. That will be better.
Oh. Next.
Item 45, 46 have been disposed of. Item 47.
Here, please, Your Lordship. The petitioners, they are the teaching and non-teaching staff of a aided institution. They are aggrieved by, and the order passed by OP number 3, that is DEO, who has passed an order for recovery of the increments. Can you see page 32? Page 32, they have passed an order that the earlier increments which were given to them will be modified and the excess will be recovered from them.
How many years of service you have got?
My lords, our order of appointment from 1995, Your Lordship. 1994. Our first date, some 91, some 94, Your Lordship.
No, how many years of service you have got yet?
Left, my lords. The petition number 1, 7 years. Petition number 2, 2 years. Petition number 3, 1 year. Similarly, Your Lordship, because the staff.
Take emergent notice.
Can I say one thing, Your Lordship? Just fancy Annexure 7 for movement. And under Annexure 7, Your Lordship, under similar circumstances, has quashed the impugned orders and remitted the matter back to the district education officer.
Well, that was the case of the
similar matter, Your Lordship.
Followed, saying that no opportunity of hearing was given.
Same here, Your Lordship. Same, Your Lordship.
For that, we have to issue notice now.
As the Lordship pleases.
You, Mr. Sen, accept notice. Just tell it next in the first week of January. I'll keep this matter. Except covered by judgment also.
Except operated by the
Issue emergent notice. 1, 2, 3, Mr. Sen appears. Emergent notice to 4. Matter lies in a narrow compass and covered by appears to be covered by decision also. Therefore, first week in the second week of January.
There's an IA, Your Lordship. There's an IA.
Let us see.
There was recovery, Your Lordship.
How much money?
My lords?
How much money?
Increments from 1986, Your Lordship.
The application is moved. Seeking stay of impugned order. Mainly on the ground that the same has been issued without following the rules or principles of natural justice. First off, counsel also submits that there is no fraud and fabrication alleged against his client. Therefore, the recovery needs to be halted. First off, there is force in this submission. Next, in the above circumstances, application having been favored, recovery is halted till next day of hearing. First, since this order is past ex parte, it is open to the official to seek variation of the said order if grounds do exist therefore.
I'm much obliged.
Then first week of the
Item 48.
May I please, my lord?
Yes.
Chapter 8 of the Urban Police Act, my lord. It deals with the power of the police to deal with unclaimed vehicles, my lord. Lord, the petitioner is a dealer of the car of Toyota make, my lord. We have got a workshop. There are near about 29 vehicles, my lord, which came for servicing to the workshop. And thereafter, my lord, it has been abandoned by the respective owners. Despite notices to them, they are not claiming the vehicles, my lord. In view of Chapter 8, my lord, the police has the power to deal with unclaimed vehicles found or made over to them, my lord. My lord, your lordship would see that Annexure 3 series. Well, this is the condition of the vehicles, my lord. Lying in the workshop for years together, occupying the space as a result of
are they involved in accidents or crimes, etc.?
My lord, nothing, my lord. They came for, it was given for servicing, and thereafter, despite notices to them, they are not coming forth to claim the vehicles, my lord. And we have also written to them, still then they are sleeping over the issue, my lord. Your lordship would see Annexure 6, my lord, in terms of the Urban Police Act, we've also made a representation to the local police having jurisdiction, my lord.
Let him consider the representation.
Yes, my lord. That
But it's a case of bailment, where vehicle is given to the garage man.
Yes, my lord.
It's a case of bailment.
Yes, my lord.
How police will interfere in that?
My lord, so let them take a decision, my lord, because the urban police.
Read the section.
Yes, my lord. Yes, my lord.
The private arrangement.
My lord is right. Your lordship would say chapter 8, powers in relation to unclaimed property. 61, section.
Unclaimed property with the police.
No, my lord. Unclaimed property found or made over to the police. Suppose,
read the
yes, my lord. Section 61, police to take charge of unclaimed property. It shall be the duty of every police officer to take temporary charge of all unclaimed property found by or made over to him, and B, of all property found lying in any public street, if the owner of or person in charge of such property on being directed to remove the same refuses or fails to do so. 2, the police officer taking charge of the property under subsection 1 shall furnish an inventory thereof to the commissioner.
No.
And
this is not a private, these vehicles are not on the public property. They are in your private premises.
My lord, so far as B is 61B is concerned, my lord, it says in the public street.
Correct.
But so far as 61A is concerned, my lord, unclaimed property found or made over to the police.
Found or made over to police. For example,
yes, ma'am.
Police people find unclaimed property. That property, they can take it to their custody, and whatever they 98, 99 Supreme Court, they can auction also is another thing. Where there is a bailment, it excludes public power. This is covered by chitty on contract. Where owner of the vehicle entrusts the property to the garage man.
Yes, my lord.
It is a case of bailment. Why police will intervene?
No, my lord. My lord is 100% correct, my lord.
Then there is no case in your
my lord, my only prayer would be let them deal with my representation.
No, nothing like that. Where is your right? The short grievance of the petitioner is as to non-consideration of his representation dated 23/9/2025 given to the inspector in charge of Southern Police Station, Cuttack, wherein a request is made to take all private vehicles entrusted to petitioner's garage by the owners of the said vehicle. First, the Learned Counsel for the petitioner loudly reads rule, which is that
61, my lord.
Section or rule?
Section, my lord.
Section 61 of
61, 62, 63, and 64, my lord.
61, 62, 63, and 64 of Orissa Urban Police Act 2003 in support of his claim that where the owners of the vehicle have left their vehicle, where the private owners on entrusting the vehicle to the garage man do not take them back within a reasonable time, the police should act upon the act and take possession of the subject vehicles to their custody to deal in accordance with law. First one. Next, learned DSC appearing for the ordinance vehemently opposes the petition, contending that all standard books like Chitty on contract, Anson on contract say that where a vehicle is entrusted by the owner to the garage man, it is a case of bailment, and therefore interference of the public authorities is not warranted. First, this is the perfect legal position, even according to this court. First, in the above circumstances, petition being devoid of merits is liable to be rejected, and accordingly it is. First, however, it is open to the petitioner to take other appropriate legal proceedings elsewhere in accordance with law for the redressal of his grievance. Yes, next.
Item 49.
49, Lordship. My prayer is very innocuous, Lordship, and Lordship, only my repeater should be considered in a positive manner, Lordship. I
consider everybody's request in a very positive manner.
Lordship, that will
to infuse negativity in me.
No, Lordship. That's it. Only Lordship, Annexure 1. I am a Lordship sports organization. I want to be included in the sub-divisional forum. And it's due to the sub-collector to take a decision, Lordship. Annexure 1, Lordship, is 9.
Where is your right?
Lordship, it is right, Lordship, Annexure 1. It is up to the Lordship Subsidiary Committee only to Lordship accept the membership of the registered organizations, Lordship.
Where are the rules?
Lordship, in fact, that rule is in fact that's not available with me, but that is the Lordship usual practice, Lordship.
No, that I don't know. I am from outside.
Then sorry, Lordship, related Monday so that I can.
Call this on Monday to enable counsel for the petitioner to come with more preparation.
Item 50.
Netfulness.
May I please, Your Lordship? Lord, the petitioner is a retired teacher. He retired from service on 31/7/2022. My Lord, his annual increment, his next annual increment was due to him with effect from 1/8/2022, just one day later.
One day before.
Yes.
This increment accrues on that day.
Yes, on that day. That is with effect from 1/8/2022. But at the state government in finance department, relying upon the judgment of this honorable court in the case of Arun Kumar Biswal, has issued a notification, issued a office memorandum dated 22/1/2025. Your Lordship may kindly see Annexure 4.
Government employees retiring
Page 30, paragraph 4.
Grant of notional for the purpose of pension calculation.
Paragraph 4 may kindly
Pension
see.
calculation.
Yes, only for pension calculation. And my Lord, although this office memorandum is not applicable to the employees of aided institution, this is applicable to the government employees. But in view of Rule 9 of the 1974 rules, whatever pay and
to them is applicable to you.
Yes, yes. Your Lordship may kindly see Rule 9 of the 1974 rules.
Yeah, the other day somebody read that rule. You take notice. Let him take notice.
My Lord, may I suggest one thing? He has made a representation under Annexure 6. Let that my representation may be considered in the light of that office memorandum. Annexure 4.
The short grievance of the petitioner is as to non-consideration of his representation dated 21/8/25. A copy thereof avails at Annexure 6, wherein he has sought for granting of one annual increment on notional basis with effect from 31/7/2022.
No, retirement is 31/7/2022.
That's correct.
Annual increment was due to him on the next date, that is 1/8/2022.
But council submits that although the annual increment should accrue on a normative basis with effect from 1/8 first day of the August of the year concerned.
That is one day after his retirement.
The petitioner is entitled to benefit of the same in view of OM dated
and one judgment of the Honorable Apex Court relying upon that Karnataka High Court case. Your Lordship may kindly see. That has been upheld.
In view of OM dated 22/1/2025 that has been issued by the government in the light of
2023 Live Law SC. 2023 Live Law SC, page 296.
Judgment of a coordinate bench of his court in WPC number 17715 of 2020 between Arun Kumar Biswal.
Yes,
relied upon by disposed of
and that has been relied upon by the Honorable Apex Court also.
But counsel also submits that
page 37.
The case of the petitioner is supported by the decision of Apex Court in Director, Administration and HR KPTCL versus CP Mundilamani.
Karnataka High Court judgment.
I decided this matter.
Yes.
2023 Live Law SC 296.
And your Lordship may kindly see internal page 4 of that judgment.
Yeah.
Our High Court judgment has been relied upon. That State of Orissa, that is Arun Kumar Biswal versus State of Orissa and another, basing upon which this circular has been issued, office memorandum.
Next. Learned counsel submit that if direction is issued to consider petitioner's representation in the light of legal literature, justice would be met with first. Learned AGA, ASC Mr. Sen appearing for the notice very clearly agrees with the suggestion of this court that he would instruct OP number 2
to look into the grievance of the petitioner as has been held in the subject representation, keeping in view various decisions of court. First, this is appreciable. We caveats that all contentions of the party should be kept open. First, next one. 6 weeks.
Item 51.
Well, petitioners are working as a part-time gets instructions, government ITI, Chhatarpur Maila, since 2012, 2012 to 2015, my lord, more than a decade, my lord. Now they are by order at annexure 12 and 13 and 14, they reduced, that is the strength is 19, my lord. They have reduced it to 5, my lord. Total strength was 747, that is total all over India. Now they all over Orissa, my lord. Now it was 262. For which the strength was from 19 to 15, 5, they have reduced, my lord. And your lordship, similar matter also, your lordship already, that matter also you should notice, my lord. Similar matter. Only there would be only descend, my lord.
The interim order is granted.
Yes, there the lordship director, they will continue. Simple.
Let's see, the instruction I am appearing for the OP2 minor.
Issue emergent notice or Mr. Sen accept notice for OP numbers. OP number 1. Shri.
Just again, senior panel comes.
Senior panel counsel Shri so appears for
OP2 minus.
OP number 2. Emergent notice to the rest. Next paragraph. Now then counsel for the petitioner submits that in identical matter this court, identical matter that is WPC 32538 of 2025 between Kanu Charan Behera versus State of Odisha. This court has already granted interim relief by interim order dated 17/11/2025 and therefore similar relief needs to be accorded to his client as well. First, there is force in this submission. Next, in the above circumstance, the subject application having been favored, OP numbers 3 to 5 are directed to continue petitioners in service under the same terms and conditions as are applicable to him during dependency of the petition. All this along with the
So the directive server copy. So the new
Item 52.
Yes.
Well, the petitioner appeared at the annual HSC examination 2025. Well, there is
similar matters to be decided.
No, my lord. Here, my lord, what has happened? There is mistake in retotaling of marks. Your lordship may kindly turn to annexure 4, that is in respect of social science paper.
4 marks lacking.
Yes, as per calculation.
Take notice.
Yes, I will serve extra copy on Mr. Rao.
Yeah. Issue
in account.
This when the DSC accept notice for no, Mr. Rao, when the panel counsel is requested.
Yes, sir.
Notice for this matter lies in a narrow compass called the same in the first week of January 26. Next.
Item 53.
This is a case where, my lord, the petitioner is entitled to receive block grant as per the granting order of 2008 because of the pendency of a writ petition before this honorable court relating to another person.
Modification is from 39/2021.
But here, my lord, the petitioner has been given block grant as per the granting order of 2014 instead of 2008 because the writ petition was pending before this honorable court. That writ petition by another person claiming for the first post of lecturer in English. Subsequently, that writ petition was withdrawn. And thereafter, my appointment was approved. By then, my lord, so far as other employees are concerned, they had already availed block grant as per the granting order of 2008. Then I made a representation to the director, and the director, your lordship may kindly turn to annexure 15, made a correspondences with the principal on 13/6/2019 under annexure 15, then on 11/9/2019 under annexure 16, and thereafter no decision has been taken.
So your lordship may direct the director higher education to take a decision in the matter.
Annexure 17.
Annexure 17 has page 43. The representation addressed to the director higher education. That is the
representations at Annexure 17 series.
Page 43, 13/5/2025.
The grievance that the release of granting aid in his favor ought to have been under the granting aid order 2008 and not under the granting aid order 2014.
Yes.
First off, learned counsel for the petitioner submits that the mistake occurred because of the pendency of WPC number, OJC number.
OJC number 15216
of 1997.
Which was
filed by one Shri Sukanta Kumar Jena.
Yes.
Jena. And that the same having been withdrawn
on 29/3/2014.
On 29/3/2014, there is no impediment for granting the relief which the petitioner has sought for in the representation and in the petition as well. First, he submits that if a decision is taken on the subject representations in accordance with law, his client would be satisfied. First, learned DAC Mr. Sen appearing for the OPs 1 to 4, notice to 5 having been dispensed, submits that there would be no difficulty for instructing OP
number
3 to look into the grievance of the petitioner as has been held in the subject representation if all contentions are kept open and a reasonable period is prescribed for accomplishing the task. First, he also expects cooperation from the side of petitioner.
Yes.
And petitioner counsel is agreeable to do the same. First, in the above circumstances, petition is full of 8 weeks.
Item 54.
May I please, my lordship?
Yes.
My lordship, the read petition, I'm challenging the order of collector, district master Kandhamal Phulbani.
Take notice, legal heirship certificate, yes, issue, heard, Srimati Soini.
For all the operations, except operation 6.
Yes, accepts notice for 1 to 5, emergent notice to 6.
My lordship, IA can be considered, my lordship, because any time it will be issued.
But that counsel
till the next day.
This is IA number 1 of IA number 22343.
My lordship.
22343 of 2025. Support with seeking the reprieve during the pendency of the petitioner. What is that you have sought for in the application?
My lordship, OP number 6 is the stranger and she is not legally married. And collector has passed order that she is married.
The case is made out for issuance of interim relief as sought for. First, in the above circumstances, application having been favored, the Tashildar is directed not to issue, not to process the matter any further till next date of hearing.
Yes, obliged.
Item 55.
My lord, this contempt application has been filed, my lord, for non-compliance of order passed on
4/8/2025,
my lord.
Where is that order?
My lord, annexure 1 series, page 14, my lord.
Time to the compliance of lordship's order, considering the representation. I will take instruction.
Issue police notice to OP numbers. The OPs for alleged non-compliance of the order of this court.
First, this court has noted several such cases where orders of the court are not complied. First, this is not a happy thing to happen. First, yes. Yes. Sorry, the second week of January.
Item 56.
In this case, my lord, covered by the batch of cases, the MPML is transferred that your lordship has passed.
Where are just
and interim order, what difficulty has arisen? Difficulty, my lord. Difficulty what has arisen, my lord? Since interim order was there and I was not allowed to join, that is why I had filed the contempt petition. Thereafter, it has been disposed of.
The subject matter of this petition is substantially similar to the case in WPC number 20875 of 2025 and other batch of matters disposed of by this court while order dated
29/10/2025.
29/10/2025, whereby all transfer orders of the kind have been quashed.
That is, my lord, was my lord 27/11/25.
27/11.
27/11/25.
27/11/21. Not 29/10, right? But the counsel for the petition subjects that similar order should be passed in his matter since the client is similarly circumstanced. First, that is forced in this submission. Next one, in the above circumstances, petition is disposed of, quashing the impugned order of transfer, subject to what has been observed in paragraph 4.7 of the judgment in question.
Contempt petition next. Contempt
petition. Now it because of this quashment it goes now. The contempt petition is rendered infructuous in view of order in the company NWP.
Item 57.
Here, my lord, the petitioner is
Item 57.
non-compliance of the order that
Compliance I have contacted in the morning. It will be compliant.
You will comply with the order. When will you comply with that order?
I will kindly grant all this matter 2 weeks after, 1 week after.
1 week. Next week I am calling this. Learned EGA, Mr. Behura submits that on the next date of hearing, the compliance would be reported.
This is also, my lord, relating to grant of one increment.
All this matter next week.
Both the matters.
Both the matters. I am not issuing any police notice now, since you said that you are complying with this.
My lords, I have.
Item 58.
My lord, non-compliance of the order dated 10/9/25 passed by your lordship.
What was the order?
My lord, may kindly see operative portion. My lord, that is in paragraph 4.1, page 12. This court in the coordinate judgment issue a writ of mandamus to the opposite party to observe the litigant said case in any new scheme or project within 8 weeks without driving them to one more round of legal battle. The facts of this case being substantially similar.
Absolve the petitioner in
my lord
service. That's what.
Your lordship directed.
Yes, Mr.
My lords, I will take instruction.
Behura appears for peace. Okay. Call this matter week after next for reporting compliance.
Item 59.
My lord, the petitioner, my lord, is working as a Shiksha Sahaoo, my lord, since 2003, my lords. And they are belong to SC/ST community, my lord. And they have been appointed.
Continued.
My lord, I am continuing, my lord. Continuing at lordship, kindly see the order dated 37/2025.
My lords, this
your lordship, your lordship
the order is, I'll contact them to recall, my lords, because
Mr. Behura submits that he would confer with his clients and come back with the response. For next week.
my lords, kindly grant little more time.
Week after next.
Hello.
Can I come back with
My junior was addressing your lordships, my lord.
I asked her whether your senior told you not to argue.
Well, I was on my legs, that is. My lord, it's a small matter where, my lord, the advertisement itself says that while making application online, one has to opt the language in which he seeks to sit at the examination. And accordingly, he will only be supplied with the question papers in the very same language as opted for. Straight away, lordship, kindly see page 25 of the advertisement, the condition stipulated therein. The relevant, and that too, this condition was incorporated as per the government's the circular issued by the GA department for all examinations. Page 25.
Which language you opted for?
I had opted for ODI language, but they supplied me questions in English. Even my admit card says ODI. My online application says ODI, but
take notice.
But my lord, now my lord, after this preliminary examination was held after being directed by this honorable court by your lordships, my lord, the result they have published. Since I appeared in English language, my case has been ignored. So I pray, my lord, let one post at least be kept reserved. Otherwise, my lord, I will be nowhere.
Issue emergent notice. The ASC, Mr. Sen is requested to accept notice for OP numbers 1 and 2. Panel counsel who appears for
Government.
No, for 3 and 4.
3 and 4, Staff Selection Commission councils appear. I will serve a copy of.
That panel counsel is requested to accept notice for 3 and 4. Next paragraph. The net counsel for the petitioner draws attention of the court to application in IN number so and so, supported by an affidavit to the effect that he adopted for the Oriya language as a medium of writing the examination. However, the client was granted to issue the English question paper, and therefore the enormous prejudice is caused to client. First, he also tells the court that the recruitment process is going on a war footing because of some interim order passed by this court in some other matter, and therefore at least one vacancy should be kept reserved for the benefit of his 20s and success. First, there is force in this submission. Next paragraph. In the above circumstances, the OP numbers 3 and 4 are directed to keep one vacancy vacant. One vacancy intact.
In the category of Hindi teacher LTR.
In the category of Hindi teacher LTR.
Belonging to SCBC category because I belong to SCBC.
Okay. Next.
Item 61.
In this case, my lord, petitioner earlier approached this honorable court seeking direction to the Director of Secondary Education to dispose of his representation mails.
What is that representation?
Representation with regarding to termination of his service.
Termination of your
service.
You want your re-engagement?
Re-engagement. That is why, my lord, in lords, you can have a glance unless 2 series, my lord, petition was given engagement earlier.
Earlier, when, during what period you were working?
He was working, my lord, 2009, my lord. He was given appointment as a peon, my lord.
16/4/2009.
My lord. On the allegation that he was an unauthorized absence, my lord, the service was terminated.
When it was?
But, pardon, my lord, terminated, my lord, termination order issued, my lord, on 17/4/2009, my lord. No, my lord.
It cannot be.
That is not, my lord. The termination order issued, my lord, on 4/7/2010. 4/7/2010, my lord. My lord, without any notice, without giving opportunity of hearing.
How many years? More than 15 years.
My lord.
What can be done now?
My lord, the director, my lord, was directed, my lord, to hear the matter and giving opportunity of hearing to the both parties.
This happened in way back in July 2010.
But
all these years, where were you?
No, in the thereafter, my lord, he made a representation to the director
Which is the first representation? Which is the last representation?
24, page 24, Lordship, can see.
Nothing.
Page 24.
18/11/2010.
10, my lord.
After 15 years, you are coming to court.
No, what happened there, my lord, since that was pending there, my lord, the petitioner earlier approached this Hon'Ble Court. Earlier approached this Hon'Ble Court, that is, this Hon'Ble Court under Annexure 6, my lord, directed to the director, my lord, to consider the case of the petitioner.
What happened? They considered and rejected.
Rejected, my lord, under Annexure 1, my lord.
Rejected on which day?
Beg pardon? Rejected, my lord, on 4/11/24, my lord.
4/11/24. Issue notice. What is this? After so many years, when justification. Next.
Item 62.
Yes, Mr. Commissioner. 62.
Item 62. Item 62.
Sub-jail should be continued.
Vacation mode, I think. Vacation mode.
The petitioner submits that. Whether a jail should be established or not, and if it is to be established, where it should be established, and whether the established jail should be shifted to some other place or not, whether the jail should be closed once for all or not, are all decisions of the executive wisdom. And therefore, petition of the kind is thoroughly misconceived. First, I agree with the same. Petition is missed.
Item 63.
63, may I bless you? See, I have a limited prayer, item 63. I have limited prayer to direction to the opposite party to consider my representation.
What is that representation?
My representation regarding the disengagement for engagement of the petitioner as
cook.
Cook come help.
When you were disengaged?
I was disengaged in 1st July 2025.
1/7/25, what ground?
Well, see, I was serving from 20 years. From for that, see, the opposite partner, there is no such ground. He disengage me and engage another person.
Consider last 20 years he has been working.
Miles.
He or she?
She. Smiles.
Counsel for the petitioner submits that his client had been working for a period of 2 decades as a cook, and that with effect from 1/7/2025, her services have been dispensed with. First, he tells that a representation dated 9/9/20. What date? Tell me the date.
2/7/25.
2/7/2025 has been issued at Annexure 2 series. And if a direction is made to consider the same, justice would be made to give client. First, the AGA, Mr. Behura, in his usual fairness, submits that he would instruct OP number 2 to look into the grievance of the petitioner in accordance with law. Inasmuch as already OP number 5 has been engaged to do the job. First, in the above circumstances, petition is disposed of to consider petitioner subject representation in accordance with law. After giving an opportunity of hearing to OP number 5 has been first time for complying 8 weeks.
Obliged.
Registry to send a copy of this judgment to OP number 5 by speed post.
Obliged much.
Next.
Item 64.
May I please your lordship?
Yeah.
This is a case where this petitioner organization each year used to held Mahotsav and Policy Mela in the locality in question. 2022, 23, 24, 25, they have been accorded permission. Here also this year they applied, and under Annex 3 at page 9, the sub-collector writes to the authorities to give clearance so that he can accord approval. Now, in the meanwhile, I have got instruction. Those authorities have also given clearance, though I couldn't make an affidavit because I received it at the last hour. Now, this Hon'Ble Court, by order dated 5/12/2025, has been also pleased to direct the state to take instruction. My humble submission is that the sub-collector, for no apparent reason, is sitting over the matter, despite the fact that other authorities have also given clearance, my lord.
So direction to consider this.
My lord, your lordship,
let notice it will call the matter next week.
As your lordship pleases, and difficulty is, my lord, they have to make preparation 1 month before almost. It is on
Next
10
week I
month.
am calling. Next week I am calling this matter.
My lord, they were already directed to take instruction. If my friend directed to
I have
take notice.
received the instruction. There are 2 groups they have applied for function, and both the applications are under active consideration by the authorities.
When decision will be taken?
My lords, I received this instruction on yesterday, 11/12.
May I just point out one thing? Once this Annexure 3, page 9 is in existence, that he has recommended, I think he cannot again recommend another group because he has recommended this entity for consideration and the authority have responded to it by saying that yes, we are giving clearance. I couldn't file it in this of an affidavit.
How long that function goes on?
This will be from 10/1/2026 to 13/1/2026.
Only your group?
No, it's not a group. It's an entity your lordship will see.
Anyway, why your entity?
No, they have been granted permission for 22, 23, 24, 25.
Yeah.
And now pursuant to this also, the authorities have given clearance also. The sub-collector wanted a clearance from the authority.
Under which rule all this is governed by?
Well, this is, my lord, so far as the holding of Mela is concerned, there is absolutely no rule governing the field. It is, they have to accord permission because fire safety permission, electrical permission, all those permission has to be there for a Mela because otherwise...
Take a decision within 1 week.
My lords.
And your lordship may record my submission that already the authorities to whom the sub-collector wrote letters, they have given clearance. I can also file it for your lordship's perusal, though not in the shape of an affidavit. I apologize for that, my lord. But Sanu, what a copy nahi.
No, you take a decision and report it next week so that I will dispose of this.
Yes.
Why I should direct? Yes. Otherwise, something may happen there.
My lords, the problem is that 2 groups they have applied.
Anyway, you take a decision and bring that decision here so that I will examine.
Yes.
If matter is pending here, they will have fear.
Yes, my lord. And your lordship may record my submission that the authorities have given clearance. That's I'm making
anyway, everything will be open. Call this matter.
I would have copied you.
Instant. Imminently. Yes. In the meanwhile, the decision to be taken by the jurisdictional authority and a copy thereof should be placed on record before this court. Failing which stringent action may follow.
Grateful, my lord. Grateful.
Item 65.
Lordship by order dated 5/12/25. Lordship directed will entertain petition are directed to P.K. Mathil and Senior Counsel usual appeals for IDCO to take a copy. But my learned friend Mr. Mahathi says that they are a panel of lawyers, so better to issue notice.
Notice.
I think his associate is here. So Lordship kindly
you appear for
Your Lordship, I am appearing on behalf of Senior Counsel Mr. P.K. Mahanti, Your Lordship. My instructions are there that once notice will go, they will engage panel counsel.
Issue emergent notice to copy number 1 and 2.
1 and 2.
1 and 2.
Interim order may continue.
Interim order to continue. There is already interim order.
Yes, my lord. Your Lordship, my order dated 5/12/25.
Okay.
Item 66.
Yes.
This matter, the last occasion, my lord, the notice was issued as per your lordship's direction. The notice was sufficient, but nobody had entered appearance. And now the amendments in both the cases are pending, my lord. Small amendment that my friend wanted that judgment of that civil suit. I have brought in by way of an amendment.
May be allowed, my lord. Application.
My lord, in this case, I got instruction to appear on Monday. Today I will just receive the brief. Mr. Satyavadi Mantri.
The amendment is not allowed.
Miller, who is party? OP number 4, Miller.
OP number 4. So you are appearing for OP number 4.
I have to appear OP number 4.
3. So appears for OP number 4. We'll allow the amendment applications and let him file the amended petition.
Of course, amendment.
Copy of that petition.
Read petition, they will serve consolidated.
I'll serve. Serve the consolidated petition on him.
The application I numbers?
I number.
My lord, I number
17528.
in first case, my lord, 17531, and in the second case, 17528.
Wait, no, 18016.
That is the addition.
That is the addition of party, my lord.
Addition of party.
That was allowed.
Allowed, okay.
We have filed the consolidated cost settle, we have filed.
Two applications are filed in the both the writ petitions seeking leave of the court to take up amended pleadings. First, there is no objection from the other side for allowing the said applications, provided that they should be given liberty to file their counter to the amended writ petitions. First, this is fair. Next one, in the above circumstances, both the applications having been favored, leave is accorded to amend the petitions as sought for. First off, petitioners to file amended petitions within 10 days.
By Monday, I'll file.
File within 3 to 4 days. And
serve a copy to
the other side may file the objections were counter to the same within 4 days next following.
Interim also is there.
Interim order is there.
In both the cases.
Continue following the second week of.
Lord Smith fix a date.
Second week of January.
Must to pledge.
Item 67.
Well, the petitioner got retirement in 31/7/2019.
Copy of the interim application is not served. This is a dispute of matter.
Implementation of order, because final pension is not getting. It's petitioner.
What was the order?
Order only the representation, the grievance of the petitioner may be considered within 3 months, that is 24/1/2023. Annexure 1, your lordship see the order. That is this is a grievance under Annexure 9.
Take notice. Take notice. I'll call this matter in the first week of January.
Yes.
Copy of the. Yes. Next week. First week of January.
I'll serve the copy.
They will answer the person.
Item 68.
Maybe lordship, I am on BC. Item 68, there is some error in order sheet. I am permitted to file a corrected order during the course of the day.
Next week. Yes. Next week. Yes.
I am applying for the university. I'm applying for the university.
University. Oh.
Item 69.
So, item number 69, pursuant to Lordship judgment dated 30th of October 2025, Lords, we implemented it immediately by the order dated 20th 11/2025, Lords, and regularized service with effect from the date of judgment, that is 2010, Lords. And thereafter filed an application, Lords, in the matter of IA, because the Lordship had imposed a cost of rupees 50,000 for non-compliance, and I prayed to waive that amount, and the Lordships were placed to adjourn the matter for 2 weeks to comply the order, fully pay him, Lords. In the meantime, we have paid him, Lords, 11,90,882.
Sir, may I submit? Sir, 2 cases. Sir, in another cases, it is coming 11683 of 2000. They have not paid a single pay.
My friend, I have assured him because he has already retired. We have calculated his dues, retirement dues, and it will be paid. But this case, we have already paid almost 12 lakhs.
No, that also.
I assured my friend why he is so anxious, I don't know. Because
in that matter also, other matter also.
11683. Yes, sir.
And it will be paid within 10 days, I have assured my friend why he is opposing, I don't know.
I am not opposing, I am only preparing.
I am not granting your prayer. You implement both the orders, then you come before court and then the court will be lenient to you. Not otherwise.
No, my lord. This case we paid the amount. The other case because he has retired since 3 years. We are calculating his all dues, payment and pension also, my lord. That is why it took time. And I assure lordship will pay within 10 days, my lord.
Matter.
Sir, 11683 of 2024, sir.
11.
Sir, assist, sir. This is coming, sir, with
11683 of 2024.
Sir.
In that compliance is not done.
Not done.
No, my lord. He is
that
one minute, Mr. Patti, please.
Sir, sorry. They have regularized, my lord. They have regularized, but my lord, they told that the earlier case will comply only on the basis of that both the cases will be complied. But that has not, they have been paid. Single.
What is payable then?
There the other case,
what is the order? Read order.
Read order, my lord.
Read order, the lordship, I have filed the also, my lordship may look at to regularize service with from 9 to 2016, and we have done that.
9 to 2016 you have done.
Yes.
Consequential benefits have you given?
That I am taking.
And this person has already given the amount of 12 lakhs towards area salary because he is continuing service.
You are only repeating. Only you have given once. You are repeating as if you have given it 3-4 times.
No, because the other case, what I only pray, the other case.
No, there are 2 cases.
Yes, yes.
One case you have complied with.
Right. No, complied means we have paid the amount also.
Yes. Other case you have only complied partially.
The other part is he has retired because he has retired from service, we are computing his due.
You do that and then come back. You go on, you cannot go
past that order. Yes. I don't shy away, your lordship call it after 10 days, we will comply the order and come with the order.
Counsel for the petitioner submits that his application seeking rescinding of the directions for payment of cost will be considered leniently once the order in connected WP number 11683 of 2024 is also complied by making necessary payment pursuant to regularization with retrospective effect from 9 to 2016.
Right.
Next.
Item 70.
Item 70 may I plead, my lord.
Yes.
I filed an IA which is at flag B, my lord.
IA for?
IA for fixing my pay with effect from 2017 in the rank of the.
That will be as good as the final order.
No, my lord. I beg apology, my lord. The final order I have claimed with a prayer to fix my pay from the date I was appointed because that fixation of pay is in contrary to the UGC guidelines, my lord. UGC
Who appears for the UGC?
I'm appearing for opposite party number 2 and 3. We have already received the parawise. We have sent the draft counter for vetting. My lord, may come after.
My lord,
second week of January.
My whole predicament is that. My whole predicament is that juniors to me has been granted the pay fixation higher to me. They have been promoted. And I am the only one left out only because earlier I have approached this Hon'Ble court and they are acting in a vindictive manner.
The second week of January, come na?
Oh, bless me.
Item 71.
Yeah.
I am 71 in this case.
21, your lordship, kindly.
I am for the petition.
No, I am trying my IA for vacating the interim order.
No, his intervention has not yet been allowed.
Your lordship, kindly appreciate.
His intervention has not yet been allowed.
Issued an letter
For the petitioner,
giving TET qualified. They had last occasion placed. Only Supreme Court has ended the matter. Yes, your lordship, may kindly. One paragraph. 116. By invoking Article 122, they have already declared that, but the Honorable Apex Court has already declared that. State ballot.
Final disposal.
Instance of person, it has been stated.
Yes, sir. Let me
place my in senior. If you will brought to the notice of the Honorable Apex Court judgment, that paragraph thereafter will differentiate by innovating argument. Then I have nothing to say. That is to be seen, Malan.
In meantime, so far the OTT qualification is concerned, it has been well decided and it is come to the rest, my lord. So far the Anjuman Isharat case is.
Yes, yes, I am conscious of that. I am conscious of that.
System is being halted.
No, my lord, I am conscious of that.
You start.
Yes, yes, my lord, I am studying.
Now the best spelling is division bench.
My lord, my initial objection before your lordship says,
Yes. What is your prayer?
my lord, the prayer is,
Yes.
my lord, since division bench is hearing this matter and the matter has been fixed to 17th, and the virus of Rule 15 of the elementary cadre rules of 1997 is under challenge by the intervention. And
which is your matter? Which is your matter? Which are your matter?
No, he has no matter. He has filed an application for intervention.
His matter is pending with the division. Yes. What is your case?
But my case is, here, my lord, I have challenged. Your lordship may take up WPC number 14137 of 2025. That is the first matter.
Yeah. These matters challenge they have the same common factor.
Yes.
What is that you have challenged?
My lord, one writ petition has been filed before the division bench challenging the virus of Rule 15 of the elementary cadre rules of 1997, wherein, my lord, that cut-off date 11/2/2011 is the subject matter of challenge. That matter has been posted to 17th of this month. And another matter where, my lord, a coordinate bench decided the matter in our favor. A writ appeal is also pending. Both the matters have been tagged and both the matters have been posted to 17th December.
17th.
Yes, 17th.
We'll have it on 18th.
18th.
Call this matter on 18th.
Interim order to continue in the first
interim order to continue.
But may I pray, Lord? One thing. In that case, the virus of that provision is under challenge, which was issued in exercise of power proviso to 309. The power of the governor is displaced. On that day, I had also pointed out, brought to your lordship notice, in view of the ratio of doctrine of occupied field, just A.B. Krishnan versus state of Karnataka.
No, that's
my humble submission.
Decided.
Just I am decided. How it is different, my lord. I am just. It is not to be mingled to. For the simple reason, my lord.
The petitioner.
Yes, that is why I know, my lord. I know, my lord. I know. Why I am saying one sentence, bear with you for a moment. My lord, you have already submitted. My lord, my humble submission before lordship is, in that case, if the rule made under 30 proviso in contraventions of section 23 of RCFC Act and rule 17 of the RCFC rules, that is questioned there. If that will be declared ultra-virus, then that rule will be declared ultra-virus from the inception, that is in 2019. That will be decided there. But here what has happened, in 2024, 25, my lord, they have issued a letter that is directing, in terms of that provisions of the Central Act, that the TET candidates will be first promoted. Prior to 2025, 4 lots of promotion have been given to the underqualified teachers, while we are in 85,000 are available. Now government said that the TET qualified candidate will be considered for the promotions. That is under stay. And out of them, my lord, at least 90% of teacher they have acquired. Only at least some few, they have not failed even appearing the TET, or their instance is stage operating. My humble submission is, this is a promotion only to the TET. From among them, those who are in service candidates in thousands, they have already acquired TET qualification. They can be considered with our 85,000, those who are with the qualification and entered with the service. If that will be done, my lord, then promotion process will be on for the entire state. And from among them, those who have acquired in the meantime also, they will be considered. So that it will be in the interest of all. Interest of all common. That is different because 19 it will be decided. My lord.
My lord, a writ appeal is also pending.
My lord, whether, no, you have said it 10 times now.
Yes.
Whether the entire promotion process is halted now.
Yes, my lord.
No. So far as,
make it clear.
My lord, so far as level 5A is concerned, my lord, there is a letter of the director wherein it has been, your lordship may kindly see the order.
No, I am asking you.
Yes.
Whether promotion process is halted.
No, promotion process has not been halted.
Not halted.
Not halted.
You also clarify the promotion process being on.
Not
Subject
halted.
result of this case, read application, promotion process being made on.
The interim order granted by this court
Modified the text.
shall not be construed as halting the promotion process. First off. However, whatever promotions are to be effected shall be subject to result of.
Yes.
Whether process will
Come after vacation.
Matter in the second week of January.
Yes.
January
Yes.
26.
Oh. By this matter, nobody will suffer.
Nobody will suffer.
Because from them also many people will.
Yes.
One thing, you should permit petitioner to argue the matter. How can you?
Why is requesting? Why is going through?
It is for the orders for my application of interim vacation.
Your intervention application has not yet been allowed.
And that division bench matter pending for last 2 years. And he is not taking any step for dismissal. Now,
one line, if I will brought to your lordship's notice, 116 paragraph, thereby invoking Article 142, the Honorable Appeals Court declared those who have no legal qualification, they have no right to be considered at all. That is the judgment now come. It has solved the whole matter.
No, we have
That is already enclosed matter.
That will suffice. Next.
Item 72.
Item number 72, my lord. Appearing on behalf of the petitioners, you have filed an IA number 21733 seeking impletion of parties, my lord.
Petition of parties.
Addition of parties.
Who are they?
My lordship, the principal government ITI Rayagada and
take notice to them.
My lord.
Issue notice on IA. Yes.
Item 73.
My lord.
73, my lord. Yes. My learned friend is appearing in the connected matter. In the first matter, I am appearing for the petitioner. But here, what has happened? That mutual transfer was approved by the director. And accordingly, I was relieved from Nagaland district to join in Balangir district. But the district education officer, Balangir, he did not permit me to join in Balangir. Therefore, my lord, I approached the director. Then the director issued 2 orders in my favor that you implement that order. But those 2 orders have been stayed at the instance of my learned friend.
Yes.
Now, my lord, I am coming with a proposal. I don't want to disturb him since he is continuing in his previous school and I have been relieved from my parent school. I want to join in any school in Balangir. So let the government council take instruction.
Mr. Bhanti appears to be very this.
I have been relieved since 2024 and I am not able to join anywhere.
it's a case of mutual transfer, my lord.
Anyway.
Yes. Yes, both can be accommodated.
Both can be accommodated.
That's fine.
No, he is continuing. He is continuing. I only have to accommodate it.
Both the private sides in the petitions are agreeable to the suggestion of this court that petitioner in WP number
15316.
Second case. In the first case, I am the petitioner.
Shall continue in the place where he has been continuing, and that the petitioner in WPC number
31208
of 2025 shall be given posting
in any
of the schools
in Balangir district.
In Balangir district.
Yes.
District at the earliest. Since he has been without any posting.
Yes.
Since more than a year. Since about a year.
Yes.
Since about a year.
He has been relieved on 18/10/2024.
Having been relieved on 18/10/2024.
From Nuapada district. From Nuapada district.
From Nuapada district. First one. Next one. The authorities to take action in this regard for implementing of this judgment must ordered accordingly and this direction.
ordered accordingly and writ petition is disposed of.
Both the
Directing the DO, my lord, DO Balangir.
Directing the DO Balangir.
Number 3.
OP number 3 in my case.
Yes.
OP
number 4.
Give effect to this order.
OP number 4 in my case. DO Balangir.
No, you also can say DO Balangir.
DO Balangir.
Because district education officer. Balangir.
Give effect to this order. Yes, but
Both the
cases are dismissed.
Item 74 has been disposed of. Item 75.
74, your lordship. My lord, may be pardoned, your lordship. 74, my appearance may be recorded, your lordship.
74.
Your lordship, I am for OP number 2, your lordship.
Report of as having been withdrawn.
Please, your lordship. Memo has been filed on by the petitioner.
Sure.
My lord, by order dated 31/10/25, the lordship had issued notice and also held that since date was not fixed before the SMND, so lordship had given the option to file a memo when the matter will be posted. Now matter has been posted to 15th. File memo accordingly, and therefore I wanted stay of further proceeding. Your lordship, that since date has not been fixed, after the date is fixed to come. Your lordship, order dated last order dated 31/10/25. Last para.
This court, while order dated 31/10/2025, has said as that order number 2. The senior advocate Mr. Mishra, appearing for the petitioner, points out that now the date having been fixed, that is 15/12/2025, there should be interdiction of the proceedings till next date of hearing. First, accordingly, an application in IA number 19133 of 2025 has been moved, supported by an affidavit. Correct? Affidavit. First, there is force in the submission of learned senior advocate. First, in the above circumstances, application having been favored, what should be stated now?
Further proceeding in M.S.EFC case number 21 or 23.
All further proceedings.
M.S.EFC case number.
EFC case number.
21 of 23.
21 of.
Pending for opposite page number 2.
Or stay till next date of hearing.
Opposite, so far as opposite number 3 is concerned, we filed the address, we have filed the requisite with the address which he had given in the before the MSMBC. But in the meantime, the notice has come back that says that the address is not found. So I have to take fresh notice, take fresh steps for opposite number 3. Within 1 week, I'll.
Copy number 3.
Copy number 3.
Copy number 3. Immediately. Within 2 working days.
Also, please.
One, it's a writ appeal, my lord. It requires some more preparation. Lordship, shortest possible date may be given so that.
After vacation?
Yes, any date.
But we can't fix a date, as you know, this is a special bench.
Yes, my lord.
When this bench sits next.
Yes, it will come.
Before vacation, we are having only 4 days.
Five.
So 3 days.
3 days.
The last working day.
Yes.
Usually have.
It's sitting, your lordship may call, we will finish it.
The SKG for the appellate is the HP doctor for the government. The Learned Counsel for the appellate state 6 accommodations. Currently, the matter shall be listed when this bench functions next.
Item 2.
My dear, it's an application for review of the judgment dated Lord 25/7/2025, passed in WPC number 16289 of 2011.
What's the ground for review?
On the ground of error apparent on face of.
Wait, what is that?
My lord, paragraph 8 में kind of seeing. Considerately, the DP number 2 of 2011 was with regard to incumbency of the petitioner in the Court of Civil Judge Junior Division, Baleswar, from 14/7/2006 to 9/11/2010. The charge memo was communicated to the head of the office where the petitioner was working, Civil Judge Senior Division, and that was received by him. Maybe the date of receipt is not very clear. Well, here my submission is that there is evidence from record that the charge was served on him on 2nd August 2011. And the date of promotion is 17th May 2011. So, as per law initiated by the Hon'Ble Apex Court, proceeding can be said to be initiated on the date charge memo is issued. So, in that view of the matter, my submission is that on the date of promotion or prior.
You have read 9 you read. You have read only para 9 and the only one judgment is not that you read the subsequent two judgments.
Yes, ma'am.
Which judgment you are relying on?
No judgment, my lord, just I am pointing
You
out.
said the Supreme Court have said so and so, which judgment?
Supreme Janki Raman case.
Janki Raman have relied. You have a right for consideration.
The right for, I do not dispute that, my lord, but Supreme Court
Janki
says.
Raman is actually, as somebody told me,
Yes,
it is
ma'am.
against any employee. Because they say that the Janki Raman says it cannot be given promotion.
My lord.
He has only a right for consideration.
Other point is decided, my lord, that proceeding can be said to be initiated on the date charge memo.
Don't stop after reading it. Read 9.
Yes, my lord. On being asked, it is stated at the bar that the petitioner has not challenged the imposition of punishment on him, nor any challenge has been made to the alleged further action of the authorities in not considering him for promotion. Now, assuming for this.
Stop there, sir.
Yes, my lord.
That is factually correct.
Yes, I don't dispute that, but my only submission is that. My only
challenge that
is.
We do not, because you said we have some difficulty in forgetting.
Yes.
You said when we asked that, you said that actually he was not your client. So why he has not challenged when you asked you? Said that you do not know because this brief was transferred to you later.
Yes, my lord.
So we hope we are, because this proceeding is televised. In YouTube you can check it. So this was your submission.
Yes, I don't dispute
so
that.
You challenge that, we are not adjudicating that actually.
No, my lord, this is only the date of promotion. 17 May 2011, promotion order was notified. My only submission is that by that date, no departmental proceeding was initiated against him.
There is presumption that if you do not receive the charge memo, it is not initiated.
That is the deal.
Which judgment you are referring?
My lord, Janki Raman and Anil Kumar Rai.
Subsequent, two decisions are there.
It is only when a charge memo in a disciplinary proceeding or a charge sheet in a criminal proceeding is issued to the employee, it can be said that the departmental proceeding, criminal prosecution
is bar the word issued. So that we said because one of the senior advocates, he told me this.
Yes, madam.
We were discussing. It is not said received.
No, issued, my lord. Admittedly, it was issued on 1st August 2011. They have admitted it is on a record, my lord.
You are not even assuming. Kindly come to para 9.
Yes, my lord.
Para 9 you have read that. That order remains intact because you have not put in challenge that order.
No, through that my humble submission is that on the proceeding in which I was punished, that proceeding was not initiated by the date of promotion, consideration of promotion. That is my only submission. And if that is accepted.
After punishment, we cannot efface that. But suppose by kind of holding a duster, you efface a blackboard. We cannot. You should have, after immediately, you should have challenged that. And very candidly, you said that actually, maybe he was advised, you do not know what happened.
Yes, ma'am.
You later on received this brief and this matter carried on and without challenging that. And this, if you, what is the judgment on this review, which is the leading judgment on review, where this court can interfere?
If there is an error apparent on the face of the record.
Error apparent on the face of the record. You are arguing a point of law because issuance of charge memo, receipt of charge memo, period of consideration of promotion. So this we cannot. If you read Mayabati, this court is cannot review on these grounds.
And that was my submission at the time of the hearing, my lord.
Error apparent on the
that
face
was
of
the
the
only
record.
submission.
Error apparent on the face of the record is that which did not require any examination of records. You see, to what extent you have to argue this to prove?
Yes, ma'am. This is not rehearing. This is not rehearing. But since they have, the department has admitted that charge memo was issued to
the
you.
difficulty is that you may not read the other paragraphs, but we have to read the other paragraphs after rendering the judgment.
Anyway, sir.
Yes, ma'am.
Now, para 9
is
staring at you.
Yes.
Para 9 says the punishment order is not put in challenge.
Yes.
It may be a wrong order.
Yes.
But that remains intact.
Yes, my lord. I admit that.
Then where is
but my only submission is that the proceeding in which that
you have not read the third line.
Yes, my lord.
Because we have accepted your contention. Now you are just now saying we have discussed that.
Yes, my lord.
Para 9 we are not reading the third line. Rather fourth line.
Yes, my lord. Now, assuming for the sake of argument that the petitioner's case would have been considered for promotion and kept in sealed cover, the sealed cover could have been opened after the disciplinary proceeding was completed by order of punishment dated 5/7/2013.
You would have got anything.
The result would have been due to indictment.
Because
but I was not indicted by the date of consideration of promotion. That is my only submission. If it is accepted,
pendency, then again you have mixed up. You should. Pendency of a disciplinary proceeding disables you from getting promotion, but to be considered. That's the law.
Yes, my lord.
Janaki Raman also stares at us. We cannot say that you can be given promotion. So that is how we have accepted. Let us assume.
Yes,
considered.
Yes, ma'am.
You also get promotion.
Yes, ma'am.
Then what would happen?
Because of punishment order.
Yes, my lord. Because of punishment order. But I humbly submit my only that punishment was imposed on me in a proceeding initiated after the promotion. That is my only submission. If it is abstracted by your lordship may pass appropriate order.
Para 5 is factually correct. Para 8 is factually correct. Your interpretation is different. That you had received on certain date.
Yes.
Because we have observed that the data receipt of that charge memo is not very clear from the pleadings.
Not by the pleading, from the additional affidavit filed by them.
And the reason being, we did not go into there also. Because we assume that you will get promotion. We assume that by consideration, you get promotion, para 9. We cannot get over that. To review, you have to get over para 9 also.
My lord, in this case, am I permitted to submit, my lord? In this case, promotion order was notified on 17th May. The proposal for initiation of proceeding was approved on 16th May. And my submission is that by that time, consideration of possession was over. On 17th, it was formally notified. And they said that charge memo charge was framed on 17/5. So if that is
para 7, you are re-arguing again. Para 7 you read. Para 7 of the dates. And mark the dates.
Yes, my lord. Para 7. In para 6 they have admitted.
Para 3, sir. Para 3 because you are started arguing the dates also. Please check para 3.
Several issues have been raised by the petitioner, but the thrust of the argument is that petitioner should have been considered for giving promotion that was given to other junior clerks on 17/5/2011.
Then look at para 1 also. So that is your argument. Para 1 of the judgment.
Insert the contention of the petition is that when is other colleague similarly situated working at...
Prior to, the date is 17/5/2011.
Yes, ma'am.
And you are also saying 17/5/11.
Yes, ma'am.
We have considered that actually. 17/5/11. My lord, your argument is now that we have not considered 17.511 order.
Yes, my lord, I don't say that.
Yes.
I don't say that. I say that date of promotion is 75 or 17.5. Date of charge, as they say, is 17.5. But that was not issued to him. It was issued 2.5 months after.
Sir, when they consider you and you have succeeded in getting promotion, what would be the result we have considered in para 9?
Yes, my lord.
For review, we cannot ignore our observation earlier. Para 1, para 3, para 9, para 7, we cannot.
My lord, I have made my submission. It is for your lordship to appreciate.
Definitely, sir, you have to make your submission. You cannot take a decision.
When charge memo was issued, Mr. G? When the charge memo was issued? Regardless of survey, when actually it was issued?
I have no answer.
Make it clear, everything will be.
They have, may I interrupt me?
Yes.
They have filed an additional affidavit.
Where in the state?
Page 165 of the brief of the writ application.
16/5/2011. It was initiated the order dated 16/5/11.
Yes, my lord. They have that on 1/8/2011.
So 16/5/11.
Yes.
Suppose post 16/5/11.
Yes.
It cannot be ignored. In the pretext that it was sought, it was issued, not issued. Para 6 first second line.
Yes, ma'am.
And thankfully you are only for you are only concerned with para 8, but look at para 6. The DP number 2 of 2011 was initiated by order of the London District Judge dated 16/5/11.
Yes, ma'am.
And the date of promotion is 17/5/11.
Yes, but 16/5 they approved the proposal to initiate the proceeding.
That is enough.
I have filed that note sheet also. That note sheet, my main prayer is.
Mr. Das, for the authority who is considering promotion.
Yes, my lord.
They cannot 16/5. They cannot ignore 16/5. So that is how the paragraph 9. Now, because you say that you have never received or received, one way of looking at it. Para 6, the DP number 2 of 2011 was initiated by the order of the London District Judge Balaso dated 16/5/2011. So once it is initiated for any kind of subsequent events for any officer.
Yes, ma'am.
They have to take note of that 16/5 order of the district judge.
And by 16/5.
They cannot have the pretext that since so and so. It may not be this case. Any case, let us take.
But my lord, since now we are in a review, but the file would clearly indicate whether any proceeding was initiated or not.
Sir, we cannot go behind the file and assume the dates, second guess the dates. That is how we did not read para 6, only read 6, para 8.
They have admitted it was issued on 1/8/2011.
They did not issue. Actually, the Supreme Court, the language used is that due to collusion of the authority and the person,
yes,
it is just possible that you will never receive it.
Never receive because
that is the language. That is how we asked you that whether you have read the subsequent decision interpreting that Janaki Raman.
Yes, my lord.
Because once it is issued on 16/5, but suppose I have a very strong liking for you, I will not look at it.
And that
why being chairman of DPC, something issued to a particular judicial officer, I will not look at it because I like him so much. But if it is initiated on 16/5, I cannot ignore it.
It was directed to be initiated, not initiated on 16/5. My submission is subject to your lordship's appreciation. But what your lordship said.
That is the reason para 9 is very important. You should have challenged that.
Just I may be granted sometime, my lord, that the plea that when there are serious allegations and takes time to collect necessary evidence to prepare and issue charge memo, charge sheet, it would not be in the interest of the
purity of the judgment, sir. Actually, don't read the judgment, bereft of the facts. The fact here is that 16/5 there is an order for initiation of disciplinary proceeding.
Yes, my lord.
So you are very liked by me. Let us assume that I am the chairman of the DPC.
Yes,
my lord has initiated a disciplinary proceeding against he is the administrative judge. He has initiated. I like the judge who has against whom he has directed initiation. 17/5 I am sitting in the being chairman of the DPC in my administrative capacity authorized by the High Court. I cannot ignore, my lords, when I call for records. I cannot ignore lordship's direction to initiate proceeding.
But my lord, in the counter or in the additional counter or in the additional affidavit, there is no which for that procedure was followed.
That is your imagination. 16.5, we have not any invented or found out.
Yes, ma'am.
That is your imagination.
Yes,
I have gone by the records.
I have filed the copy of the note sheet.
Sir, 16.5, we have gone by the records.
Yes, my lord. This one I have to submit it is up to your lordship.
G may not read para 6 or may not say that I do not know. But still we cannot also overlook 16.5.
Mr. G, when the charge memo was issued,
I have to
perhaps
bring
that will
suffice the problem.
But he is authority. We are forming opinion based upon our observations and paragraph 8 and 9.
And paragraph 6 also.
6 also.
Rightly.
But if
my
your
lord has
records
pointed out.
reveal that as on the date the DPC met, he was not issued the charge memo at all.
My lord, it is clearly stated.
No, we have stated that.
Yes.
That is what he is saying. It is error apparent on the voice of the record.
No,
They have
affidavit.
They have already stated that in their affidavit. That paragraph 6 of the affidavit. Yes, ma'am.
That compromise collusive decree was obtained by you on which date?
That date.
Again, para 6. Para 6.
10/2/2000.
But he has been exonerated from that charge. He has been exonerated from that charge.
That is the problem you did not challenge, and now you have taken a U-turn.
No, I have not.
Because the para 9, unless you should have challenged that initiation itself. Some order could have been passed.
That punishment.
But you have only challenged on consideration for promotion.
No, that punishment will
kindly read
the promotion.
Kindly read
the promotion which has already been given.
If you can little listen to.
Yes, my lord, I am prepared.
You have to be prepared. Read the para 6. The occurrences of 10/2/2010, the decree.
Yes, ma'am. Yes. But he has been exonerated from that charge.
Which date?
5/7/2013.
That's the problem. So on the date of consideration on that 16/11, you have not challenged initiation of DP?
No DP, my lord.
But you are saying no DP, no DP. And it culminated only in 2013. So that is para 9. So if you assume that you are exonerated, what can be done by the DPC then which held on 17/5?
How could DPC know that
DPC calls for that
has been committed, my lord?
That's now you have answered, nailed the screw on it.
On 16, status start FDP. On 16, that was also not in the personal file, is a separate sheet. This is not in a note sheet. My total allegation is that the notice was, note DP was initiated, it was antedated.
In that suit?
Yes. I have the plaintiff. No doubt I have the plaintiff. But according to the Bhutan Act, there is no bar. Less than 2 acres is considered a landless person.
Observations in CORAM are To overcome that, appeal is correct. Or some other not to be. Because the surely proposed to, what is error apparent on the face of the record? The federal court said, it's error apparent on the face of the record means, which is apparent without argument also.
To the
If you need
to the open eye.
then it is not apparent. Then it can be wrong order. You can say for a review, but it's not a reviewable order.
The client is not able to go to higher courts, my lord, that's why the review.
That's challenging is not getting promotion. What
Yes.
is the challenge the DP?
By that time, DP was not initiated. Only in the counter affidavit, it was stated that a DP has been initiated.
According to you also, the charge number DP is ordered 28/2011.
Yes, well, thereafter he could have amended the writ petition.
Amended actually. Then it could have been apparent as a strategy also, it could have
Yes, ma'am.
lawyering skills.
Yes.
But on 28/11, we did not challenge that also.
But on that, I cannot make any comment because it was not with me then.
It's the same thing that I cannot say because 2011 you challenge your non-promotion.
Yes.
Promotion, nothing more, nothing less. But 28/11, you get the, according to you, I got it at 28/11.
Yes, ma'am.
So by the time I was considered, I was not served with the memo. That is how I should have been given promotion. So applying Jadagi, we have applied paragraph 9. So let us assume that you have considered for promotion.
Yes, my lord.
So by the date of promotion, since DP is pending, it will be kept in sealed cover. I went the final grade.
Yes, ma'am.
So unless you challenge that, so the disciplinary authority cannot, because the whole, you know your island of these things, how the DPC is conducted.
Yes, ma'am. But by way of a rejoinder, he has refuted that allegation. Yes, ma'am.
And para 9 is because of no record soon.
But there is no whisper about sealed cover procedure, either the counter in the affidavit, because they have not kept it in sealed cover. They have not considered him. And that is clearly visible from the initial counter they have filed. And because of such allegation, we have not given him promotion.
When did you get to article? That date is become very well.
Whether in the meantime he got promotion or not, that also I have no instruction, my lord. No, he had not got any promotion.
Subsequent consideration.
Yes, ma'am.
2013 exoneration. Yes, he should, if he has not been considered, then he should have done it also.
Yes, ma'am. That's what happened.
So we, after 12 years, how can we say that after 14 years?
Yes, ma'am.
2020 years, it was never considered also. So in fact, you say that you are not aware why, what is the reason? They are not challenged the main thing. What would have inhibited him from getting promotion?
Well, as per the then council, he did whatever he said, but in the by virtue of rejoinder, all these things were given. No, no, that is because
whatever instruction he has submitted, he must have done accordingly. Chado. Now.
One instrument to the
Original DP file, that is what. My lord, after the judgment, I'll bring that. I'll bring.
He said,
I'll bring that. That will clarify. But in the review petition, my lord.
No, that's only going to be assessed.
My lord, I'll bring that.
An error occurred on the base of the record can be in respect of a record which you have kept in your cupboard. If that is sealed, then it can be an apparent.
I'll bring that DP2, I'll bring that.
Therefore, produce that record.
I'll
Where is the
in the next city.
May I play, my lord? Promotion file. Promotion file. Yes, my lord. Previous order was there.
And demonstrate the state's ambition. However, that is maintained from the whether there is an error occurrence in the case of the car can be certain after looking into the original file, which may be at the hands of the dog.
Judiciary.
Restore. And which may be saying, will of people. First, for our satisfaction, we want to keep the file to ascertain that the intention to simplicity the portion of the bar is correction. First, in was instances, she requested people that the fight original promotion.
Yes, sir.
DP2 of 2011. DP2 of
along with the information, we will be able to put instructions and HTML. First, all this matter, then this very together. It cannot be. But anyway,
I'll bring that.
I will be stating it.
Yes,
particular.
Obligement.
Item 3.
Non-compliance of your lordship's order. Again. Last paragraph of your lordship's order.
Yes, Mr. G, what is the order? What is the mandate? Why mandate is not complied with?
It is the Swearers Board. Has to.
And the official of respondent, it is also the government.
Where is the mandate?
Case 42, my lord.
42.
My lord.
It reads like this, the decision has.
The appellant board and the official respondents are directed to implement the impugned order of so and so, and report compliance to the Registrar General of this court within an outer limit of 3 months. Default or delay shall be viewed very seriously in the next legal battle.
No, that's all right.
If raised,
Who should implement?
the government should be blamed, my lord. There is a direction for the government for creation of the post.
Yes, Mr. G.
My lord, I had no instruction in this matter.
You gave instruction and come back.
Yes.
Notice is not yet ordered.
No, no.
Notice was not issued.
Issue notice. Mr. G, accept. Should we, you accept or shall I issue police notice?
No, I will accept.
Mr. G accepts notice for the OPs. For the they are called as
OP2 he will
they
accept.
called accused or OPs in criminal in contempt. Say what is the
Contempt. Proposed contempt.
Local the opposite parties. After to reject their
They are proposed contemners.
OP numbers 1 and 2.
No, OP2 he will accept. For OP1 I have to take
The board
notice.
is there. Swearers Board.
Let OP1 notice go emergent.
Yes.
Issue emergent notice to OP number 1. For OP number 2, Mr. G accepts notice. First. call this matter when the bench next assembles.
Requisites mane by Monday I will file.
Requisites within 3 days, 3 working days. Okay.
Item 4.
May I please, Your Lordship?
Yes.
Your Lordship just have a glance to order that at 29/11/2025. This is the matrimonial appeal I am for doing. Initially, learned Judge Jajpur has benevolently asked order that 20 lakhs my client got satisfied, and the mode of payment has been that is stated here. Your Lordship has passed order that 15 lakhs would be deducted from the terminal benefit of my husband, and that would be deposited in my account. And how that will be deducted? That is Controller of General Defense Accounts, Air India Force, New Delhi, that he will deduct that amount.
May I submit, my lord?
Yes.
My lord, I'm sorry, my lord, virtually. My lord, in past order, even though the Ministry of Defense is not a party, but it is a judicial order passed by the Honorable Court, I communicate the same by mail to the defense control accounts. It may some time, my lord, let's me keep it after vacation in the manual. Once again, twice I've on 3rd and 10th. Both day I communicate the same. Also send it by the registered court, because who is the control of defense account is in Allahabad and Delhi, and different officers are there. I don't know which account is coming under this. So I sent it to the defense secretary and the control of defense accounts also. So let me work someday, in some time, otherwise it can be follow up, man. That's why I'm seeking some time.
But then actually, you should, because we, without hearing them, we have to pass the judgment. I know chance to.
But twice he has sent that order to them.
To them, but he's himself not sure who is. Maybe Allahabad.
I will send one copy of this order to the court itself, will speed post.
Mr. Padi, could you ascertain who will be the most effective authority for this? Well, I seek this, locally there is an officer, he was in leave, that's why I could not ascertain which officer is coming under this. So I wrote a letter to them, they will confirm me, my lord. Within few days, they will confirm the officer. Definitely, I will communicate the order once again also.
Mr. Padi, the DSG submits that a short accommodation may be granted so that he would confer with the concerned official and ensure compliance of the order. First of all, for that purpose, call this matter when the bench next reassembles.
Item 5.
Lord, item 5, my lord, senior is out of station. My lords may hear, my lord and senior, I will be taking notes and my senior will address on the next occasion.
No, that will not be helpful. Because what madam will argue, your senior should hear that.
Then, as your lord, my lord, as per your...
Lordships, maybe after vacation, if you're
Of course, after vacation.
One, if date is fixed, then both of us will I understand Mr. Hon'Ble is also busy.
Difficulty because
And I understand.
this is an accidental bench.
The problem I'll tell you, Lordships, is this. Why this Friday, even last time Saturday also I missed. I'll tell you the whole thing is what happens is most of the seniors, that is the day they go to all the commercial courts to do the one. That is the day. Normally, Friday, last hour, Saturday.
So other than Friday, we should put this.
No. I am saying, I'm just telling diverging the truth.
Many times, even when we had the pleasure of being at the bar, we used to do that also.
Because the entire week we don't leave High Court at all.
Correct. We'll keep your view in our mind and we'll instruct the registry also. Learned counsel appearing for the OPs submit that the arguing counsel is not available and therefore short accommodation be granted. First time. What is not present? Well, the bench next assembly. Now, then have to put it on some other way instead of sticking here. Yes.
Item 6.
May I please, your lordship?
Yes.
This is a matter wherein the order of the Honorable Single Judge has been challenged, passed in WPC number 343 of 2011 of 22, on the ground that there is 2 points. One is the Honorable Single Judge said that I have not retired from the post of multipurpose health supervisor. I have retired from the post of sanitary inspector. That is point number 1, to which I say that it is a factual mistake as per the record available on the service.
The post of?
I am actually retired from the post of multipurpose supervisor.
Where is that show?
The WPC 311. There.
Page number?
I'm coming.
Because judgment, the very first sentence in para 2.1 begins.
Yes.
Petitioner retired sanitary inspector.
Yes.
That's not correct.
Yes. In the informed judgment, they say so. But that is contrary to the records available on record.
Yes.
So, page number 58 of the Carson Reed petition.
58?
Page number 58 of the WPC 343/11/22. There it is. This is my retirement order.
Where is that?
It is there.
Read.
As per the order dated of Chief District Medical Officer Noyagad, Sri Lokanath Mahapatra, the petitioner and the appellant, a sanitary inspector bracketed MP.SW male of this PHC is hereby retired from his on date 30/6/1994. This is they say.
That is sanitary inspector only.
Sanitary inspector bracketed MPS.
That's a different post.
Yes. I have joined in the post of sanitary inspector. In the due process of my service, I was promoted to the post of health assistant. Then after my designation was redesignated as multipurpose health supervisor. That is the counter filed by the AG that they say available in 445 of 2018. That record I have called for in the last, I have read for that record. That record has been brought. 445 of 2018.
What is the effect of this change of designation?
It decided that the persons who retired from the post of sanitary multipurpose health worker on coming of the 6th pay is effective from 1/1/2006 came effect from 2018. They shall get the higher benefit of pension. They will get the revision of pension. The grade pay plus the basic pay plus the grade pay, 50% of the basic pay and grade pay.
That you are not getting because we are shown as a sanitary inspector.
Actually, they say that as because you are not retired from the post of, as the counter says, of OP number 3. That is contradictory to their own documents. In their own documents, they have admitted that I have retired from the post of multipurpose health supervisor. I may kindly be allowed to read page number 2 of the counter filed by AG, available in OA 445 of 2018. Because the AG, that is paragraph number 5. As regards to brief fact of the case, para 6 of OA, it is humbly submitted that the applicant, while holding the post of sanitary inspector cum multipurpose health supervisor under Borapundusar PSC, has retired from government service with effect from 30/6/1994.
Mr. G,
Oh, it is Aziz, my friend is here. You will also know.
Ah, yes, this is the AG, this is the counter of the AG.
Issue notice. AG requested lots of notice for OP numbers 1, 2, 3, 4, 4. First up, the panel council 3. Right, so accepts notice for
Standing council. Standing council.
Accepts notice for OP number 5. Okay.
Item 7.
I may point out another point.
Why? We have already issued notice.
That is another document available where it says that I belongs to the multipurpose health supervisor, got training, got promotion, all the things.
For admission, we have to make a point.
Yes.
You have made it.
Yes.
So matter requires due consideration. When your matter is taken up, you can argue on that. 7.
Item 7.
Item 7, my lord, signed for the appellant twice, my lords. On last order, your lordship, on last occasion dated 29/11/2025. Yeah. That's on last occasion, my lords, an order was passed that a writ petition has to be tagged along with this matters because the issues are connected, my lords. So a copy was to be served. My learned senior is saying that he will serve a copy. It was to be served, it hasn't been. They will serve a copy, my lords. It may be taken up any other date because I do not know. I am not aware of the contents of the writ petition yet.
Who should give copy to you?
My learned friend.
Yes, brother, there is an order.
Yes, madam.
Give copy.
Yes, madam. By Monday, I will serve the copy, madam.
See how much time we are wasting. Well, this could have been done long ago. This is the reason why pendency increases.
Because, my lord, earlier notice has been issued to the in the read.
Anyway, now don't waste further time. Give copy of the.
So, and it was also been.
I think in the REIT, they are appealing. No one is appealing.
In read, Union Bank of India and the present appellant is the opposite party.
Exactly. So that is how we said we should have served.
So earlier when notice was issued, it was been sufficient.
The ill health of Mr. Parikar's father, he's pattern appeared, he was outside, he said that I has not mentioned it in time.
By Monday, my lord, I will serve in the call.
3. So I will take to serve copy of the writ petitions along with all the documents on learned counsel appearing for the wife.
Mr. S. Sharma for the.
Yes, sir, ma'am.
Mr. S. Mahato. R. Mahato, sorry. R. Mahato.
Same order. When national examples.
Item 8.
In item 8, your lordship last occasion on 29/11 directed me to file compliance. My lord, we shall file compliance. My lord, I had talked to them. Lordship gave me short time. The problem is that there is no such post available now. So they have to create a supernumerary post. I had talked to them. They will prepare moving the file to comply your lordship's order.
This court-wide order dated 29/11/2025 had said as that. First, next. Learned AGA Mr. G, in all fairness, submits that before the next date of hearing, compliance would be reported by creating a supernumerary post if need be. First up, we appreciate this and act upon that. First up, call this matter when the bench next for report.
My lord.
There are two judgments of the case. Let's see. We need not create supernumerary
Posts at all. Wherever equivalent matchable posts are available,
we are
even there we can do
yes, we are doing that.
Under the same department, there are other.
We have other department also.
Yeah,
what you need is one job, one boat for sailing. It need not be on the Gangetic waters. That's.
We are also doing that. That also.
Yeah. Other option to accommodate the petitioner in the existing vacancies of matchable posts are also kept open.
Yes.
Is also kept open.
Better on the next
Next.
sitting.